Hey guys, let's go do your own research. A very happy Good Friday to everyone watching. We have a lot to get through tonight. We have an update on the summary judgment, an order from Judge Lehman. So yesterday I was all set to dial into the public hearing. Happy Good Friday, Kayla. I was all set to dial into the public hearing. I had managed to get access to a internet phone line. And then when I dialed the number and put in the ID number, it said the hearing was full. I was like, no way. Because I kind of left it to the last minute because I didn't realize that the battery was dead on the laptop. So I was like quickly trying to charge it up, like literally on the dot of it starting. But just before that, there had been this update on the docket. And so Judge Lehman had made an order on this summary judgment thing, and it was like 152 pages. So then I went to X to see what was going on with the hearing. That was adjourned. So yeah, then I started reading the document, and then I went to bed, and then I thought, okay, I'll read it today. I'm definitely going to do a live stream. I have read it through. There's a lot of headlines coming out saying that most of it has been dismissed. So yeah, as usual, we're going to read what's really going on. But I thought I'd start a little bit different tonight. I'm going to play a news clip because I thought, let me start with what the news tells us. Yeah, it's real quick, but it's interesting. People talk about the media being biased, but let's see what this report says.
Tonight, a major blow to Blake Lively's sexual harassment lawsuit against her. It ends with us co-star Justin Baldoni.
I would never lie to you.
I know it's nothing.
It's nothing?
Yeah.
Lively's lawyer said she was kissed, nuzzled, and touched without her consent, and that Baldoni was consistently inappropriate. But a federal judge today dismissing 10 of her 13 claims, including harassment, defamation, and conspiracy, over key legal requirements related to classification as an employee.
She was not an employee who could bring those claims that only an employee could. She was an independent contractor. So she had no chance of winning on those claims at trial.
The pair have been locked in a headline-grabbing legal battle since 2024 that at times has drawn in famous names in text exchanges with her husband Ryan Reynolds and pop star Taylor Swift. Last year, a judge dismissed Baldoni's $400 million countersuit against Lively, alleging defamation and civil extortion. Lively's team praising the move then.
It was a sham lawsuit designed to retaliate against Ms. Lively for speaking up against what she experienced on set and to silence others who might come forward.
But tonight, a win for Baldoni's team, saying they are very pleased as a narrower set of allegations against Baldoni's production company now head for trial.
All right, Emily, let's pick.
Okay, so that's what they said. I know it's really interesting. They never said anything about the sanctions that his team were, what's it called, that they got last week. Also, I just want to replay this little bit because I don't know if you spotted this, but look at this. Look at this edit. Look at this clipping. Ready?
I would never lie to you.
I know it's nothing.
It's nothing?
Yeah.
Lively.
I would never lie to you. I know it's nothing. Are you telling me they playing with us, getting that clip, that particular clip in the whole movie? Yeah, so I just think some of these news reports are crazy. Like, if you don't really do your own research and pay attention to this stuff, it's really easy to be thinking that there was no sexual harassment. I know, right? And I'm not being funny, but NBC is one of the better ones that I saw. So another thing that I've noticed as well is I don't think either party have actually made a statement, but well, sorry. Sigrid McCrawley, she made a statement immediately after. She is very good at media. She made a statement immediately after saying that this has always been about retaliation. So yeah, retaliation is going to be heard in front of the jury. Let me go back to the, well, let me go to the document, sorry. So they have their expert in the studio on Go Do Your Own Research. You get me. And it's fair to say I am not a legal expert by any stretch. With that being said, I think a lot of the legal experts that have been very much leading the narrative on this case till now have not said anything about what actually happened, about any of these judgments. So that's what we're going to get into. That is what we're going to get into tonight. So we've got the intro. I'm going to try and read it as quickly as possible. Obviously, I'm not going to read through 152 pages. We have the background. We have the film at the heart of the lawsuit is based on a successful novel by Colleen Hoover of the same title, and that both the book and the film explore the issues of domestic violence. I remember during the hearing, one of Baldoni's lawyers, I think it was Bach, said something about it had to have a sexual aesthetic. So interesting that they've put that. So basically they said that she was engaged after a meeting in New York. She agreed to play the film's lead role, Lily Bloom, and her agreement to perform that role is documented in an offer letter dated May 4th, 2023. So yeah, the meeting happened in 22 at the end of the year. Then they started filming May 23. Filming stopped, May 15th. Filming stopped on June 14th due to the strike action. And then several months later, on November 9th, in anticipation of the strikes ending and filming resuming, Lively's attorney sent an email to Wayfarer. And it ends with us listing a set of 17 items that they would have to address to remediate their alleged misconduct before Lively would agree to return to production. Entitled, Protections Will Return to Production. Okay, on January 4th, they all met at her apartment. We all know all of this. The protections were later incorporated into a contract rider agreement signed on or about January 19th, 2024. That bit's important. Production resumed on January 5th, 2024, and took place primarily on the New Jersey set, with a few additional days in California. Filming concluded on February 9th, 2024. Following the following weeks, the parties worked on editing and promoting the film. Lively indicated that she did not wish to jointly promote the film with Baldoni, concerned that her appearance with him would be viewed as an implicit stamp of trust or approval of him. The film premiered in New York on August 6, 2024, and was released to the public on August 9. Okay, so then this is the bit that makes me laugh, because I'm like, can you believe all of this was over in the run-up to the premiere and after Lively and her husband, Ryan Reynolds, had unfollowed? Oh, I noticed I can do something new. Unfollowed Baldoni on social media. Wayfair and Baldoni worked with their public relations consultant, Jennifer Abel, to engage crisis communication specialists, including Melissa Nathan and Jed Wallace. We know a lot about them. As well as their respective firms, the agency group TAG and Street Relations. What happened next is hotly disputed and will be described below. In short, Lively claims that Wayfarer Baldoni and their consultants engaged in a campaign to injure her reputation in retaliation for her claims of hostile work environment. Yeah, so we know all of this, but just a quick recap. On December 3rd, 2025, Lively filed memoranda of law in opposition to the motion for judgment on the pleadings and the motion for summary judgment. Yeah? I actually did a video on the live hearing on that motion for summary judgment and the motion for sanctions, which was, I don't know what the word is when you get sanctions. Upheld. Sanctions against Friedman were ordered. Okay, so the court held oral argument on the motions of January 22nd. Yeah, that was the day I did my video on. So then we've got legal standard. I'm going to flick through that quickly. Oh, I actually made some notes. Let me check my notes. Okay, yeah. So then we want to go to discussion. So this is just basically explaining what the legal standard is, and it's very long-winded and it's very technical, but just one line says summary judgment is appropriate where the movement shows that there is no genuine dispute as to any material fact. A genuine issue of material fact exists if the evidence is such that a reasonable jury could return a verdict for the non-moving party. Yeah, so it's like basically a summary judgment is when the judge decides there's no need for this to be heard in front of a jury. Spoiler alert, he decides it does need to be heard in front of a jury. The movement bears the burden of demonstrating the absence of a genuine issue of material fact. In deciding a motion for summary judgment, the court must construe the evidence in the light most favourable to the non-moving party and draw all reasonable inferences in its favour. So then we go on to discussion, which is Lively brings 13 claims against the Wayfarer parties, which are 1, sexual harassment in violation of Title VII. So Title VII is a civil human right in America. I think human and civil rights. Oh, human rights of the civil Rights Act. So it's against discrimination, basically. 2, retaliation. So you've got to look at all these different violations, because this is the important bit of Title 7 of the Civil Rights Act. And then sexual harassment, number 3, in violation of the California Fair Employment and Housing Act, aka FEHA. 4 is retaliation in violation of FEHA. 5 is retaliation in violation of California Labor Code section. 6, failure to investigate. 7, aiding and abetting harassment and retaliation against Nathan, Tag, Abel, Wallace and Street Relations. 8, breach of an agreement called the Actors Loan Out Agreement. So that's the ALA. Breach of an agreement. So this is where we're going to get really into how this failed. 9 is breach of the Contract Rider Agreement, the CRA. So if you noticed at the beginning, the protection list came under the Contract Rider Agreement, sorry. 10 is false light, invasion of privacy and violation of Article 1, Section 1 of the California Constitution. 11 is sexual harassment in violation of California Civil Code against Baldoni and Heath. 12 is defamation and defamation per se against Wayfarer, Baldoni and Heath. And 13 is civil conspiracy against all defendants. So Wayfarer were looking for a judgment on all claims. Their motion for judgment on the pleadings and summary judgment overlap in many respects, to the extent that they do not, however, the parties dispute whether the court should, in considering the motion for judgment on the pleadings, also consider factual disputes presented in the motion for summary judgment. Lively contends that even if the Wayfarer parties have identified some deficiency in her pleadings, the court should conform the pleadings to the evidence in the summary judgment record and evaluate the Wayfarer parties' arguments on that basis. The Wayfarer parties respond that the motion for judgment on the pleadings tests the sufficiency of the pleadings, and that the court therefore must not consider extraneous materials outside the pleadings in its analysis of that motion. A recent Second Circuit decision sheds light on this issue, and it suggests that Lively has the better of the argument. Even if the allegations in the complaint were insufficiently detailed to survive a motion to dismiss, had such a motion been made before discovery, if the evidence collected in discovery raised triable issues of fact, it would have been appropriate for the plaintiff to amend his complaint to conform to the evidence thus collected. Dismissing the complaint at that stage, when the evidence adduced in discovery may have been sufficient to survive a summary judgment motion, would hardly serve the efficient or just resolution of disputes, which is the very foundation of the federal rules. Here, the parties have completed an extensive and fiercely contested discovery process. The Wayfarer parties' motion for judgment on the pleadings came toward the end of that process, and only shortly before its motion for summary judgment. In these circumstances, it would hardly serve the efficient or just resolution of this dispute for the court to limit its analysis solely to the pleadings, rather than the entire record on summary judgment. I'm just noting little bits and pieces. In any event, this dispute ultimately matters very little, as the Wayfarer parties have identified only a handful of allegations which they believe should be disregarded in consideration of the motion for judgment on the pleadings. and those allegations are immaterial to any determinations the court reaches. So let's go to the contract claims. Oh, I just seen we got Ghost Cat in the chat. Good evening. Can you make a statement? It's so annoying how they report. The judge isn't saying the sexual harassment didn't happen. Yeah, we are going to get onto that, Ghost Cat. I didn't want to give too much away. I'm trying to give fair coverage here. There are still people that are like, where can I go to get an unbiased reporting of the case? Like, I haven't chosen what side I'm on yet. So I'm trying to give an objective view here. But I do see a lot of people saying that the media is biased. That media report, you cannot tell me that media report was not biased against Lively. Or, let me put it another way, women in general. That's what I get from it. And like I said, that was one of the good ones. He denied them because of jurisdiction and employment class. Exactly, yeah. There's a lot of argument about the contractor, independent contractor versus being an employee. Very frustrating, but one thing I have noticed is there is not one thing to say that any false claims were made, that any lies were told, that anything that she did claim, she didn't have good reason to make a claim. That has not been expressed one time in this entire 152-page document. I will just say that right now, right here and now. Not a ruling that the conduct didn't happen, and now that only corporations remain as defendants since all individuals were dismissed. Yeah, I mean, this just shows you how, although we have these laws that are supposedly supposed to protect us as individuals, as women that are discriminated against, unfortunately more than men. I'm sorry, men don't like to hear that, but it is actually true. Yeah, the legal process will always favor a corporate decision. I'm sorry, but that's just fact. That's just how it goes. So I think, if anything, this has been extremely educational on understanding how you think these things are illegal, and they are. I mean, it is illegal to be sexually harassed at work. But then you have to decide whether you're, because she sued under a contract law, that became the issue, not the fact that there was a hostile work environment and that sexual harassment took place. And that's the unfortunate thing about the reporting that we see of this case, is that people have wanted to focus on whether the sexual harassment took place or not, whether she was making a false claim or not. As I just said, when we read through the bits that I'm going to read through, and I'm not ignoring anything that does say it, there's nothing to show that she ever made a false claim. So anyone that's saying that is talking out of their behind. Let me get back to my read through. So, contract claims. So IEWUM is the LLC for the movie. It ends with us, movie. And Wayfarer is obviously a separate entity. I do remember at the deposition, I don't think anyone knew who owned the movie. Anyone who worked at Wayfarer, I should say. they seem to have very little understanding of their own corporate law, of their own corporations' rights as well. But yeah, so where did I get to? Her 8th cause of action alleges a breach of the ALA. And her 9th cause of action alleges a breach of the CRA. Lively grounds her claims in 2 provisions of the agreement, paragraph 7 of the ALA. So that's the Actors Loan Out Agreement, which prohibits sexual harassment and retaliation, and paragraph 10 of the CRA, which prohibits retaliation against Lively for raising concerns about misconduct on the set of the film. Now, the problem here, guys, is, in plain English, because I have literally been reading this thing all day, the ALA that was made, that was created by I think it was IEWM, was never agreed and signed to by the time the movie finished. It wasn't signed until July of 2024. And so the problem for Blake Lively is that she used that ALA as a binding contract, and legally it turns out that the law favored the Wayfarer parties because of that contract not being signed, and they argued it wasn't enforceable, and that's what they won on. So that's what this is going to be all about. They argue in the alternative that even if the agreements are enforceable, there was neither a breach nor cognizable damages. The court recounts the facts relevant to these claims before analysing the merits of the parties' respective arguments. So the problem is, while they were working on the film, they were under the agreement of the offer letter. That's the problem, yeah? Because everything was rush. She signed on in December 2022, or she agreed, and it was right at the end of December 2022, and they were going to start filming in May. And she had another film going as well. So they had a 6 weeks turnaround time. So it was a lot of pressure for her to sign that contract, for them to get everything drawn up and agreed. Bear in mind, they had to move the location of the film set to accommodate her to be able to appear in the movie, because they really wanted her to be in the movie. Following additional formal negotiations regarding Lively's appearance in the film commenced in mid-December 2022 when Emini Mezziani, Wayfarer's Vice President of Business and Legal Affairs, sent Lively's representatives a draft letter offer. I mean, they say mid-December. I remember it being around the 20th. And I mean, that's just before Christmas as well. Following additional negotiations and exchanges of drafts, the parties circulated a final version of the offer letter on May 4th, 2023. That letter sets forth an agreement between Lively's loan-out entity, Blakell Inc., defined as lender, and It Ends With Us Movie, LLC. The special purpose entity, Wayfarer Incorporated, to develop and produce the film. Blakell agreed to furnish Lively, defined as artist, to provide acting services to IEWM in the role of Lily Bloom in the film. Among other things, the offer letter specifies the timing and location of filming, Lively's compensation, her mutual approval rights over certain aspects of the production, and her credit as an executive producer. Let me use my... Oops. I clicked on the wrong... Her credit as an executive producer. So I hope this is making sense to people who don't understand employment law, because it certainly was. This is all news to me, but I've just been figuring it out. And you know what I've noticed as well is, like, I did look on Reddit yesterday, and I noticed that a lot of the comments were like, "We've been trying to tell you this is what was going to happen." I'm like, you have not been trying to tell us this is going to happen. I have not heard one person say a damn thing about a loan out agreement versus a long form contract, or whatever the other name is called. Well, I mean, it's news to me if they have been saying that, but I haven't seen anyone talking about that, which basically is what this comes down to. Because also the reason why the actual contract wasn't signed for so long is because they were arguing over the sexual harassment clause. But they don't say that in the comments either. The offer letter contains no terms regarding sexual harassment. So, four days later, on May 8th, 2023, the outside counsel for It Ends With Us movie, whose name is Joseph Lanius, sent Lively's counsel a draft of the ALA, which would serve as the long form agreement. Yeah, that's what it's called, long form agreement, mentioned in the offer letter. With an inducement to be signed by Lively. Wayfarer was not made a party or signatory. Oops. Was not made a party or signatory to the draft agreement. That is very relevant. The first section of the draft ALA is titled Conditions Precedent and provides that the company's obligations under this agreement are conditioned upon. Yeah, I'm going to skip ahead to paragraph 7. Paragraph 7 of the standard terms titled Sexual Harassment further provides that sexual harassment of any type is strictly prohibited and calls for immediate termination of this agreement by a company. No employee shall be subjected to sexual harassment by another employee during the course of employment. For the purposes of this policy, sexual harassment is unwanted conduct of a sexual nature which adversely affects another person's condition of employment and or employment environment. Don't apologize, Ghost Cat. I honestly really appreciate having you guys here. I really do. It's first of all, I didn't even know if anyone was going to turn up tonight, because I know it's a bit earlier than normal. But also, like, I'm trying to get everything correct as I can, and so having you guys prompting me, it really helps. No man's law has ever prevented violence from being committed on me. Yeah. Right. Let's get back to my reading. Right. Where was I? Such harassment includes, but it's not limited to any unwelcome sexual advance. Yeah. I would say kissing on the lips. Just saying. Requests for sexual favour or other verbal, non-verbal or physical conduct of a sexual nature that interferes with work is made a condition of employment or creates an intimidating, hostile or offensive environment in connection the workplace or the use of one's authority or power, either explicitly or implicitly to coerce another into unwanted sexual relations or to punish another for his or her refusal. You see the bit about the authority or power, that's why they tried to say that they needed someone else to do the disciplinary action, because can someone in control of the corporation be trusted to discipline themselves against inappropriate conduct? For the avoidance of doubt, sexual harassment may occur between or amongst persons of different sexes or genders or of the same sex or gender, and may be initiated by any gender or sex. In the event company is aware of any sexual harassment conducted by artist, company shall have the right to immediately terminate this agreement and available to all rights and remedies hereunder. The ALA was not signed when the first phase of filming began 1 week later on May 15th. In fact, although negotiations continued for more than a year, the parties agree that Lively never signed the ALA. On May 19th, 2023, Lively's lawyer sent an email stating, "Thank you for sending the long form. We will review and come back to you with our comments. In the meantime, since principal photography has commenced, until such time that the long form is fully executed, our client will continue to proceed in reliance upon the terms of the offer letter, with the understanding that lender and artist are now unconditionally pay or play for the acting fee of 1.75 million. Nice work if you can get it. And that the conditions in paragraph 13 of the deal memo, i.e. the conditions precedent section, are now either satisfied or waived. There is no evidence of a response from counsel for It Ends With Us movie, and principal photography continued. In February 2024, 9 months after It Ends With Us first shared a draft of the ALA with Lively, and just days before filming wrapped, her representatives finally sent a marked up version of the agreement. And she proposed revisions to approximately 20% of its provisions, including ones related to execution of the ALA, publicity limitations and still approvals, sexual harassment, and confidentiality. So those were the bones of contention. Among other things, Lively's counsel amended paragraph 7, that was the one I just read out, of the standard terms, the sexual harassment provision, to add that sexual harassment was not only cause for immediate termination of this agreement by company, but also by artist. In the event artist is aware of any sexual harassment conducted by company, notwithstanding the terms of paragraph 16 below, lender and or artist shall have the right to terminate this agreement, shall remain entitled to full compensation, and shall have the right to avail themselves of all rights and remedies hereunder and under applicable law. So that wasn't signed. At this point in time, filming had nearly concluded and the parties had already conferred certain benefits upon one another. Lively had provided her acting services. It Ends With Us, meanwhile, had wired Lively's upfront fee of $1.75 million, less $6.37 New Jersey withholding tax, to Lively's client trust account at WME. It also paid for Lively's meal and training allowances and booked her travel. IEWUM's counsel flatly rejected these proposed revisions in correspondence on March 7th, 2024, with respect to the sentence added to the end of the sexual harassment provision. They wrote, "This is not acceptable. There can be no instances where there is a right to terminate the agreement or have a right of injunctive relief." It Ends With Us movie also rejected Lively's attempts to remove the conditions precedent from the agreement. In response to Lively's assertion that the requirement of an executed ALA had been effectively waived in practice, It Ends With Us movie counsel stated, "It still needs to be left in as it is always in every deal I have ever done." It Ends With Us movie similarly responded to the comment bubble, asserting that execution of the inducement was not a condition precedent to your obligations at this point, stating, "Yes, having signed an agreement along with all exhibits is always a condition precedent." Disagreement over these terms continued, with Lively reintroducing the edits in a draft on April 18th, 2024, and It Ends With Us rejecting them once again in a subsequent draft. Following these exchanges, Jamie Heath, told Lively's representatives in a May 3rd, 2024 email that, "We have withdrawn our request for your client to sign her agreement in order to extend the time with the edit." The end of that email notes, "As for future resolution of the contract, we will stand by in hopes that we come to a conclusion soon." So there's a lot of to and froing on this. A final draft was exchanged on July 2nd, 2024, with disputes regarding the contested provisions still unresolved and Lively's proposed additions once again struck from the document. Anyway, so I'm not going to go too much into all of that, but you get the picture. On December 15th, 2023, Lively provided Mezziani with a side letter which outlined the list of 17 protections provided in the November email, along with certain updates and minor modifications. This is really important. Lanius confirmed receipt of this document, also known as the Contract Rider Agreement, or CRA, and in an email on January 3rd proposed certain revisions. On or about January 19th, 2024, Heath, acting on behalf of It Ends With Us movie, signed the CRA. Lively also signed the agreement. Sony executive Ange Giannetti testified at her deposition that It Ends With Us movie executed the CRA because there was a tremendous amount of money that had been invested and spent, and we had to finish the movie or it was unreleasable. The final CRA begins by stating that reference is made to the ALA and that the parties, meaning It Ends With Us movie as company, Blakely Inc. as lender, and Lively as artist, wish to confirm the conditions under which lender has agreed to cause artist to render acting services on the picture following the break in production of the picture related to the 2023 WGA and SAG-AFTRA labour strikes. A prior version of the CRA referred to the ALA as unexecuted, but Lanius deleted that word in a draft among other edits. Okay, so the CRA further states that for good and valuable consideration, the receipt of which is hereby acknowledged, IEWM agrees to certain additional terms and conditions, including the following condition found in paragraph 10. There shall be no retaliation of any kind against artists for raising concerns about the conduct described in this letter or for these requirements. Any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work, oh, it's not working now. Yeah. As a result of these requests is retaliatory and unacceptable and will be met with immediate action. Okay, so then Wayfarer's side argued that the ALA was unenforceable because it was never validly formed. And then there's a lot of discussion about that. So I think I was going to jump to page 20. Oh, so then there's this thing about estoppel, which when I looked that up, so that's when someone makes an argument which is agreed to, and then later on they change it. So you can't go back and change your legal argument if you've already kind of established it. I think that's what estoppel means. Yeah. So even if you find out that something isn't what you thought it was or isn't correct, it's too late. So yeah, this is contract formation. So much, honestly, it's really boring. I can't even tell you. Okay, so we're going to jump to the bottom of page 27, which is the bottom paragraph. You get confused by the legal jargon. I don't know how I read this whole thing, but I did do quite a lot of looking up of stuff. Film rights, it ends with Off Movie LLC is the direct owner of the screenplay and production assets. It's a sub of Wayfarer Studios according to USPTO. Yeah, what I do understand is that apparently it's completely normal for every production to have an LLC for every project that it works on, because otherwise it's about liability. So if something goes wrong with one production, they don't want it to affect another production, basically, or be liable. Yeah, so page 27 on the contract formation says, applying these standards to the facts of this case, it is clear that the ALA is not and has not, so they spent all that time discussing this, never been a validly formed and binding contract, as it ends with Us Movie unambiguously expressed an intent not to be bound absent a fully executed and signed agreement. Consider first the language of the agreement. In both the offer letter and the ALA, it ends with Us Movie expressly reserved the right not to be bound prior to execution. Paragraph 13 of the offer letter states, producer's obligation to artist hereunder shall be subject to full execution by artist, lender, and producer of an agreement in a form reasonably acceptable to all parties. The ALA contains similar language. The first draft and all subsequent ones shared by It Ends With Us movie assert that It Ends With Us movie is not to be bound absent receipt of executed copies of this agreement signed by lender and artist. The ALA also states that It Ends With Us movie is not to be bound unless it receives the inducement attached hereto and incorporated herein by this reference, fully executed by lender and artist. This express reservation of rights, absent assigned writing, in not one or two but 3 different places, is compelling evidence that there was no mutual assent to the formation of a contract. So that's what this comes down to. That part. Where a question of intention is determinable by written agreements, the question is one of the law, appropriately decided on a motion for summary judgment. That is the case here. The written agreements include open terms, call for future approvals, and expressly anticipate future preparation and execution of contract documents. The message is clear. It Ends With Us movie did not intend to be bound prior to execution, since in this case, intent can be readily determined by examining the agreements. Summary judgment is perfectly appropriate, even if there was considerable partial performance. This is where it's literally the legal system that is against this process. I mean, in terms of achieving the justice against being harmed, because I consider this to be harmful, very, very harmful. Additional factors, including the context of the negotiations, confirm what the agreements on their face suggest. It Ends With Us movie on multiple occasions sought Lively's signature on the ALA. Lively on multiple occasions withheld it. Those requests and that withholding were not meaningless. They evidence the parties' shared understanding that execution of the ALA carried with it legal consequences. Lively argues that her withholding of her signature suggests at most that the parties continued to disagree over a limited subset of terms, in her estimation about 20%, not that they disagreed over the formation of the contract in general. But 20% of an agreement provisions is not an insubstantial amount, and the specific provisions at issue also are not insignificant or immaterial to issues of formation. One of the contested provisions is the very one under which Lively now sues. Paragraph 7. The law was not on her side because of this agreement not being signed at the time of the filming. Unbelievable, but this is the law. The question whether Lively would have the unilateral right to halt production of the film if, in her view, sexual harassment occurred is hardly inconsequential. The fact that the parties were not able to come to terms on such provision provides powerful evidence that no contract had yet been formed. So she's contending that the party's partial performance of the ALA and their written statements about it reveal that they intended to be bound by it. But obviously they didn't. That was her legal argument. So I'm going to jump ahead a little bit. The Wayfarer parties argue their performance took place under the offer letter, not the ALA. There's stuff about the travel being provided. It ends with us movie chartered a private plane for her travel. The offer letter requires it ends with us movie to provide private round trip air transportation for Lively during shoots outside New Jersey and New York. The parties conduct during filming therefore reinforces that Lively's counsel made explicit that the parties would perform under the offer letter until such time that the long form is fully executed. So she's saying, look, they were doing all of this other stuff, so I just thought that they were going to comply, I think. As for the party's post-filming conduct, Lively argues that she was paid after the film's release in accordance with the more generous contingent compensation arrangement outlined in the ALA rather than under the offer letter. But a party can provide a more generous benefit to a counterpart in anticipation that an agreement will be reached without at the same time committing itself to all of the terms in a written agreement before the agreement is reached. That is the case here. There is no evidence that It Ends With Us movie provided those benefits because it believed that it was bound by the ALA. By the time of post-production, Lively had repeatedly rebuffed It Ends With Us movies entreaties for her to sign the ALA. It Ends With Us movie also had repeatedly and unequivocally rejected Lively's counsel attempts to strike the execution language from the agreement, even assuming that Lively is correct and that It Ends With Us movie paid her under the ALA. That partial performance cannot reasonably be understood to reflect what would be a conspicuously silent change of heart on It Ends With Us movie's part. I mean, I guess that they've got a point there. The thing I don't understand is I don't understand what difference it makes, but I guess it's because she sued under that agreement. I don't know. Does that mean she can have, because if she had amended the complaint at the time, that it could have been different? I'm not too sure. Could have been a different outcome. Okay, so I was going to move to, because I don't want to read everything, but I'd written down page 33. There's a lot of arguing about these points, and it's kind of painful to read. So on page 33, this is an email exchange between Jamie Heath and Lively's representatives while they're still trying to sort out this agreement. The email continues, as for the future resolution of the contract, we will stand by in hopes that we come to a conclusion soon. That was Jamie Heath. Clearly, Heath did not understand the contract to be resolved or concluded, nor did he agree that Lively did not need to deliver final executed copies of the ALA. He merely communicated that Lively could edit the film while negotiations were ongoing. Indeed, after this email, It Ends With Us continued requesting Lively's expedited review and signature on the ALA, and Lively continued to refuse to do so. Baldoni stating in a June 1st, 2024 text that Lively won't sign her contract. Yeah, because she was negotiating like a boss bitch. I mean, if we're going to go back to their image that they think women should be listened to and given equal placement in the workplace, that is really out the window by now. Finally, Lively seizes on the fact that on January 3rd, 2024, during negotiations over the CRA, It Ends With Us movie struck the word unexecuted from the phase unexecuted actor agreement. The fully executed CRA states that reference is made so that certain actor agreement previously stated reference is made, whereas the draft CRA previously stated reference is made to that certain unexecuted actor agreement. There are no discussions or other materials in the record shining any light on that edit. The edit cannot be read as evincing the parties' mutual intent to be bound by the then extant copy of the ALA. Who comes up with this wording? At the time the edit was made and the CRA was executed, Lively's counsel had not yet gotten back to It Ends With Us movie with its promised comments on the draft long form. Lively had not even suggested the changes to the ALA that she now relies upon and that are at issue in this case, e.g. those over sexual harassment. Page 34. Ultimately, Lively fails to confront what is the central dilemma in her claim. She contends that the ALA became binding on It Ends With Us movie at some point while the parties were still negotiating it, but she cannot pinpoint a time when the parties began to be bound by it or which version of the ALA they were bound to. The existence of a contract requires a mutual assent and intent to be bound. Unless both parties are bound, neither party is bound. Which draft of the ALA bound Lively? Was it the version that lacked the sexual harassment provision? At oral argument, Lively's counsel suggested that the ALA became binding once the parties began performing under the agreement, which counsel stated was the beginning of filming in May 2023. I remember this being tweeted, but if that is so, it would mean that the ALA became binding before the sexual harassment provision was even proposed. See, this is the thing I don't get. Even that, if that is the case, we still heard at the depositions that there was a handbook with the policies of the production company, which said that anyone that they engage with, regardless of whether they have employment status or not, it could be someone delivering a parcel, that person is protected against sexual harassment or misconduct. That's the bit I don't get. But I'm just a mere normal person that does not understand employment law. And this isn't even employment law. This is like someone just pointed out in the chat. I think it was Kat. This is corporate contract law. Okay, let's move forward a little bit because I don't want to get too stuck on this. But this is essentially what the whole summary judgment was about. So then we've got waiver of the conditions precedent. I'm going to move to page 43. It's about so this is about wavering. That was about wavering conditions precedent. So then there's notice and cure. It ends with Us Movie offers one last reason why Lively's ALA claim must be rejected. It argues that there was no actionable breach of the agreement because Lively did not satisfy the ALA's notice and cure provision. The court agrees with It Ends With Us Movie here too. The elements for a breach of contract claim under California law are blah, 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 blah. So I guess they're saying that she sued for breach of contract and there was no contract to breach. In the most basic terms. Page 43. Page 43 says the relevant states' laws also matter. This court has previously explained that under the federal rules of civil procedure, whether a plaintiff or defendant bears the burden of pleading satisfaction of a notice and cure provision is determined by the elements of state law. As elucidated in Silverado, California law requires plaintiffs to establish compliance with clear and unambiguous notice and cure provisions where the provisions define breach around notice and cure principles. Other states might allocate the burdens differently. The court therefore turns to whether Lively satisfied the notice and cure provision in the ALA. She did not. In her summary judgment papers, she points to no notice that she sent and addressed to It Ends With Us Movie, which specifically raised the specter of the breach of the ALA. The November 9th, 2023 email sharing the protections for return to production made no mention of breach of any agreement, which makes sense given that the ALA had not been executed then, and the offer letter contained no terms regarding sexual harassment or retaliation. The December 20th, 2024 cease and desist letter was not addressed to It Ends With Us Movie and therefore plainly failed to comply with the ALA's specified notice procedures, which required a writing addressed to It Ends With Us Movie. Under the attention of Jamie Heath setting forth the specific alleged breach, Lively did amend her CRD complaint on December 30th, 2024 to name It Ends With Us Movie, but simply amending her complaint again failed to comply strictly with the ALA's notice procedure. So that was what I was wondering. The CRD also made no mention of the ALA, instead focusing extensively on the CRA. That is true, because I hadn't heard about this ALA, which goes back to my point raised by the comment sections of various subreddits, where they're like, we told you this was going to happen, because I haven't seen anyone talking about it. If Heath got his way on the contract, would it impact the conclusion at all? I don't know, probably. I mean, the way I look at it is Heath wasn't doing any of this out of being smart. I think they've just really winged it with this one, to be honest. I think the fact that another issue was the state of California law not applying because most of the film was made outside of California, where the protections are much looser. So that is another thing to consider, which we are hopefully going to get onto. So I had made a jump from... Okay, I'll just read that last bit of page 45. In sum, Lively has failed to raise a triable issue regarding It Ends With Us movie's breach under the relevant contractual language, given her non-compliance with the ALA's notice and cure provision. I mean, how is that for a reason to have your claims dismissed? Talk about a technicality. So technical. Relevant contractual language. Summary judgment is therefore warranted on this claim for an additional reason. The CRA is enforceable. So this is the inclusion of the protection list, the 17 points in the CRA, and that actually gave her some rights to sue on the retaliation. That's what that's about. So I'm not going to read all of it, but that's basically what it's saying. I don't know why I had jumped to page 85 all of a sudden. Page 51 says, It Ends With Us movie also argues that Lively's claim under the CRA fails because she cannot prove damages. It Ends With Us makes 4 arguments in this respect. Lively cannot recover consequential damages or what California law calls special damages under the limitation on damages clause in the ALA. Lively cannot recover emotional distress damages for breach of contract. Lively's alleged contract damages are improperly duplicative of her alleged statutory damages, and Lively cannot recover damages for the lost profits or royalties of 2 entities she controls, Blake Brown Beauty and Betty B Holdings LLC, for lack of standing and because such damages are speculative. None of these provides a basis for granting judgment on Lively's CRA claims. To begin, the Wayfarer parties argued that nearly all of Lively's asserted damages are consequential or special damages, and that such damages are barred by a provision in the ALA stating that in no event will any party hereto be liable for or have any obligations to pay the other consequential and or incidental and or special and or punitive damages. This argument fails for the same reason that the notice and cure argument above fails. No analogous provision appears in the CRA. The parties never agreed to the ALA. They are not bound by it. The court need not reach that issue, however, as Lively does not ground her opposition to summary judgment on the basis that she is solely entitled to damages for emotional distress and loss of reputation. Finally, It Ends With Us movie argues that Lively cannot recover for lost profits to Blake Brown Beauty and Betty B Holdings. Lively responds that she is not seeking relief in her capacity as a shareholder, but rather direct damages to her own business reputation in connection with her own legal claims. The court has the authority under Rule 56 to determine a fact that is not genuinely in dispute, including an item of damages. However, the exercise of that power is discretionary. The court can decide that it is better to leave the matter for trial. In this case, the parties devote only a few pages to Lively's theory of damages. The issue is better addressed at trial or prior to trial through motions in limine directed to the admissibility of evidence and argument. So that's saying that this has affected her business properties. And it's better addressed at trial. Okay, now we're getting on to the employment status. And this is so boring. But like Ghost Cat said, what was decided in this document is that okay, so there's this thing called Title 7, which, like I said, that refers to anti-discrimination law. And so it covers employees. But because she had this contract with them, she wasn't seen as an individual employee, but rather as an independent contractor who had a lot of rights. Unfortunately, being able to prevent sexual harassment doesn't seem to be one of them. But that's essentially what this is all about. And I think that is why I jumped to I mean, who knew that we were going to see this huge argument about whether she was an employee or an independent contractor, and that would affect her claim? Because I don't remember seeing anyone talking about that, unless I missed it. So they're talking about all the rights she had over making decisions. But then she was an executive producer, so I don't know. I don't see how two things can't be true. These are all the things she was involved in during the film. There's no dispute that in addition to a flat sum guaranteed as payment for her work in the film, Lively was entitled to contingent compensation based on the film's performance, as well as compensation in the form of credit and bonuses for awards. Oh, so then this bit was about the you know, the, what's it called? The hours, the 12-hour portal to portal, the turnaround time. So I don't know if you remember when I did my reading of, well, I did a reading of the trailer, what happened in the trailer deposition. And that was what Jamie Heath was his concern, was that if he didn't have this meeting with her there and then, she wouldn't have the 12-hour turnaround. Yeah, so it's a 12-hour portal to portal, i.e. drop off at home until pick up at home the following day, turnaround if artist stays in Manhattan. So she has to have a 12-hour time between being dropped off and being picked up the next day. And so he didn't want that to be eaten into by having a meeting to discuss her needs. So it says, analysis, the undisputed facts reveal that Lively enjoyed a degree of economic independence sufficient to make her an independent contractor. Although not every factor weighs equally in favour of that conclusion when viewed in isolation, analysing the factors collectively eliminates any genuine dispute. That means that Lively cannot bring a claim under Title VII. And I was reading all this, and it's like, she had the right to approve any behind-the-scenes shooting and any use of footage, any outtakes, the press and crew on set, and any interviews. It ends with us could not issue a first press release mentioning her as an actor without her approval and could not issue any additional press releases mentioning her without her approval. She had control over hair and makeup. And the Wayfarer parties did not have the right to cast an actor as her double without her prior written consent. Oh my God. Her name, voice, or likeness could not be used in merchandise. Well, they tried to... Didn't they try to use a body double on the book? Commercial tie-ins, co-promotions, soundtrack, novelizations, publications, and or in connection with advertising and or promotion of a theme park or theme park attraction. Don't. What kind of theme park attraction could come out of that movie? I really don't want to think about it. Without her prior written consent. Yeah, so she had a control over all this, but apparently not over his behavior. She had power as a matter of the day-to-day reality of the party's working relationship, but did she though? Lively described Baldoni in the PGA letter not as an employer, boss, or superior, but as a partner in all creative and logistical concerns. It is undisputed that, among other things, she reviewed and reshaped the production and costume design for all key locations and characters, performed significant rewrites of the script to incorporate feedback from the cast, studio, distributor, author, director, reviewed and instated COVID-19 protocols, led meetings with all department heads, the studio and the distributor, oversaw a team of editors and coordinated and managed cast and crew's various schedules for the film's press and release. Lively emphasizes that Wayfarer parties had the right to control her performance because she had to render her acting services when and where they were directed. I would argue that that was a good point. Like, you can see visibly that she looks very uncomfortable when he does the improvised dance scene. So to argue that she had control over it, I think it's a bit strong. It shows a kind of a poor understanding. I mean, I think some people have been saying this, is that if someone even in her position can be subjected to this kind of mistreatment, let's just put it like that for now, then what about the average person? They tried to use her body double, misled Hoover on what the cover actually looked like, then acted all surprised they got sent a cease and desist. I mean, there's just been so much underhand behavior that has been exposed to anyone that's actually paid attention. Riles roll with the punches coaster. I don't even understand why that would even be in there. That is a crazy clause. Yeah, I mean, it's funny because I know quite a little bit about theme parks. I actually did a job at a theme park once, an artist job. So in case anyone doesn't know, my job is actually now I am an artist and I have done a job at a theme park. And I didn't know, but they have used some very suspect characters to do collaborations with at theme parks. That's a whole nother rabbit hole you can go down. Brett Grace is in the chat. And made to feel like you'd be retaliated against if you come forward about your experience. Hi. Oh, you're welcome. I had to go there. I had to do this. You know, because I know a lot of people are feeling upset, and I'm like, yeah, it doesn't look good. But then at the same time, let's just go through it. Let's see what's really gone on here. Like, to be honest, I have so much respect for her actually seeing this through. Anyone that thinks this is a win in general is not very clever. This is not a good day for the female population in the US. Well, I mean, probably not just the US, but you know what I mean? Like, this was someone asserting their very, very most basic human rights, and basically the legal system has just said no, not today. Okay, so I'm going to skip ahead a little bit. It's about talking about opera performers. It does get better, actually, this filing as it goes on. Okay, page 67, it says, Lively may have been subject to some extent to Baldoni's direction in the end. I'm just doing my highlighting. In the end, he was the one to call for lights, to direct the camera, to start shooting, and to tell the actors when to act. But his discretion was also not unlimited. Baldoni, too, was subject to constraint on his creative freedom. Don't we know it? He was required to direct according to the script and did not have control over the script. For him to depart from the script, he needed Lively's assent. This is what I'm talking about. If, for example, Lively did not want a scene to deviate from the screenplay in a particular manner, he could not direct her to do so. Yeah, but he sure as hell pushed it to as far as he could in trying to get his own way. Oh, that's where it says, moreover, while it ends with us movie owned the screenplay and enjoyed the authority to hire members of the cast and crew, there is evidence that it shared the practical ability to exercise that authority with Lively. Did it share the practical ability, or did it kind of use her for clout? Depends which way you look at it, really, doesn't it? But I guess the I guess Judge Lehman isn't going to relate to those kind of sentiments. So this is still going on about how she's an independent contractor rather than an employee. Oh, this bit was... these factors ordinarily are not given decisive weight in the Title VII context for fear that a wily employer might, by contract force, I think this is really important, might by contract force its worker to give up her statutory rights and thereby opt out of the anti-discrimination laws. In this case, however, the particular circumstances do weigh at least somewhat in favour of independent contractor status. Yeah, but it feels to me like that was kind of what the issue was, you know, because she did waiver a formal HR process in respect of an agreement moving forward that the sexual harassment would stop. But instead, she got an even worse scenario where Justin was sneaking around, having his sneaky little group chats and rages and plotting and scheming and bitching. Because I really think where he started to lose it was during the edit. And that was very much still part of the working time. When Jamie Heath was like, oh, okay, well, we won't sign the contract just yet. Sneaky little snakes. She also received substantial equity in the project. In her words, she owned a huge piece of the movie. So all of this is telling us is that she was under a lot of pressure to not cause any disruption to this film. Because she had a lot to gain out of it doing well. Or is it me seeing it like that? The provisions for award bonuses and credits suggest she had a stake in the project independent of what her work would generate for the common enterprise. The offer letter entitled her to bonuses for an Academy Award, for a Golden Globe Award, or for a SAG Award. And as noted, 2 on-screen credit in paid advertisements, and to executive producer credit, first among all other executive producers. Okay, so that was all in the offer letter. These people that were saying about she used this opportunity to promote her products and all of this stuff. Of course, it was all agreed at the start. So it's just all about money. Finally, there is no dispute that Wayfarer parties were in the business of producing films and that Lively's work related to that business objective. The Second Circuit has cautioned, however, that whether a hiring party is in business indicates nothing about whether the hired party was an employee in that business, and that this factor will generally be of little help in this analysis. Okay. There is limited case law bearing directly on the status of an actor as an independent contractor under the federal anti-discrimination laws. Wow, that's interesting. That's what I'm saying. That's what I'm saying. But the court's conclusion is consistent with the case law that does exist. This is another case law about a Puerto Rican television show. What the hell? Okay. California law. Okay, so the end of that section was, because Lively was an independent contractor, the Wayfarer parties are entitled to summary judgment on her Title VII claims. So that's all it was. California law. The Wayfarer parties also argued that Lively was an independent contractor and not an employee under California's business-to-business exception, such that her section retaliation claim must also be rejected. Well, you lost that one, didn't you? Okay, let's move to page, I think it was 85, where it started to get interesting. They're just saying the same thing over and over again. I just think it's crazy that this Title VII thing is being kind of held against her because she's an LLC, or, you know, because she's like higher up the employment status ladder. The presumption against extraterritoriality. I can't believe I can say that word. So we get to page 85 and it says that the ALA, so Lively's principal contention is that the territorial reach of these statutes is beside the point. Because the parties expressly agree that California's substantive law would govern all disputes arising out of or relating to Miss Lively's services under the ALA. The ALA, she argues, is conclusive with respect to the statute's application here. The Wayfarer parties disagree, responding primarily that a contractual choice of law provision that incorporates California law presumably incorporates all of California law, including California's presumption against extraterritorial application of its law. I don't know why I jumped to this page. This dispute poses an interesting and important question regarding parties' ability to contract around extraterritorial limitations in state statutes. It is not one, however, that the court need address, as the ALA was never executed and is not binding. The premise underlying Lively's argument that the parties expressly agreed to apply California law to all disputes is therefore incorrect. For Lively to claim to obtain relief under the California statutes, she must demonstrate that her claims would not violate principles of extraterritoriality. Lively's claims. Lively asserts that her California sexual harassment and retaliation causes of action are sufficiently related to California such that they do not implicate extraterritoriality concerns. Courts addressing the question whether a case falls within the territorial limits of Federal Employment and Housing Act and California Labor Code section blah, 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 apply the framework that the California Court of Appeal outlined in Campbell. Campbell involved, this is another case. involving a crude oil shipping company. The relevant inquiry then is not where the employer is based, but where the wrongful conduct occurred. Damn. So she was arguing that they were based in California, therefore their conduct should come under California law or civil law or whatever it is. And the court is saying, no, you weren't injured in California. That's what this bit is about. Anyway, that's about territorial jurisdiction. Let's now get to the actual sexual harassment claims and what they say about that. Lively brings sexual harassment claims against the Ends With Us movie, Wayfarer, Baldoni and Heath under FEHA and against Baldoni and Heath under California Civil Code. The crux of these claims is that the defendants harassed Lively and subjected her to a hostile work environment on the basis of her sex and/or gender. Lively's allegation centre largely around conduct which occurred on the set of the film during the first phase of production in New Jersey. This on-set conduct occurred outside California and cannot support applying the statutes extraterritorially. Recognizing as much, Lively asserts that the key decisions that enabled, escalated, and perpetuated the hostile work environment were made in California by executives supervising Ms. Lively's employment from Wayfarer's California headquarters. Specifically, she alleges that Baldoni and Heath made critical pre-production decisions from California that enabled harassment to occur and left cast and crew without protections once filming moved to New Jersey. I don't see any lies told there. For that proposition, Lively asserts that Heath, acting from California, failed to hire a separate HR presence for production, even though Baldoni had a potential conflict of interest as the film's director and Wayfarer's chairman. It goes back to the power thing. Lively also points to Wayfarer's failure to provide sexual harassment training to cast and crew after Sony informed it that Sony would not be responsible for the training. Lively asserts that these California-based management decisions effectively guaranteed that once filming began, there would be no meaningful mechanism for Ms. Lively or any other cast member to report inappropriate behavior. Lively alleges that additional conduct in California set the tone for harassment. Shortly after Lively accepted the role of Lily Bloom, Heath sent the following text message to Baldoni. I was going to say, what set the tone for harassment for me was when he talked about his private parts at their first meeting. But I think Blake Lively has a very high tolerance level in that kind of department. Shortly after Lively accepted the role of Lily Bloom, Heath sent the following text message to Baldoni while Heath was in California. By the way, I'm at home with my daughter, husband, and wife. What? Oh, daughter's husband. I was like, he's got a husband. I'm at home with my daughter, her husband, and wife, with a visit from her midwife that delivered Justin's kids and my kids, going through the process for her home birth at my house. It's very magical. This all to say, the energy of bringing life into the world is surrounding us. We are birthing Blake into this role. It's just such a weird and creepy thing to text someone. Especially as they're trying to argue that she's like this powerful business entity that's got all this power to control what happens on in the making of this film. And also, that would never be said about a man. Never, ever, ever. Lively states that this comment sexualized her and invoked female reproductive imagery to describe her professional contributions, signaling that her value was tied to her gender rather than her talent. Lively points also to the fact that during a pre-production Zoom meeting, Baldoni, presumably joining from California where he resided, lashed out at a female producer for disagreeing with him and subsequently sent an apology to that producer, also presumably from California. I guess we're talking about Alex Sachs here. Lively further states that when she and Slate complained to Jannetty about Baldoni and Heath's behavior, Jannetty, who was in California, failed to act because she did not believe Sony was responsible. When efforts were finally made to address Miss Lively's complaints by other female personnel, they were done via negotiation between Sony, Wayfarer, and Miss Lively's personal counsel in California. Lively contends that the harassment also continued after filming. Let me have a look at my chat. Oh my God, I would love you to go to the trial. That would be so awesome. Are you going to wait at 4 a.m? No, if you go to the trial 100, I want to do like a live stream with you outside. That would be so cool. You knew better than to expect her to win on SH. I mean, to be fair, Kayla, I've not read it out yet. We're just about to get to it. She hasn't. It's not like they are 100% are not saying there was no SH. They're actually saying there was SH. What they're saying is what she sued them under doesn't apply to the SH, I guess. I mean, it still baffles me as to how I'm just like, how are the legal commentary channels going to spin this? Because I can just imagine them like, there's this guy called, oh my gosh, I've forgotten his name, but I think he did the Gwyneth Paltrow case coverage. But I just don't know how they're going to spin that she's got a case for retaliation for complaining about sexual harassment if there isn't a case for sexual harassment. Do you know what I mean? It's just going to be really difficult for them to to make sense of that, I think. If the claims weren't valid due to jurisdictions or whatever, why would the judge have not realized that until now? I mean, that's a very good point, but it wasn't so much the geographical jurisdictions as this was a response to the summary judgment that the Wayfarer parties went for. So that's where, as I said at the beginning, the summary judgment is that they put forward the case that this doesn't need to go to trial because we have indisputable facts and we can resolve this without a trial. Yeah. But then, so this is the judge's response to that. So obviously they really, really strongly argued these points about the loan out agreement not being signed and how because of that it's not enforceable because that was what she used to sue them. So really it's about that. And so how did it not come up before? I'm not too sure, but that's basically how I read what's happened here. I guess again, when we were seeing that they were going for a motion for summary judgment, we knew that a lot of the facts could be disputed, and he's basically said that in this document. He said a lot of times this could best be decided in front of a jury. So again, that's why a lot of the headlines are quite misleading. The edit was when he was possessed by a child. Heath was too busy to exercise him. Oh, you're assuming he didn't want to be too hasty. He wanted to play out reduced risk of an appeal. Yeah, that's another thing. Like the judge has never said once during this entire document that she doesn't have a case. He's just saying that what she wanted was incorrect, is how I read it. You're worried there won't be enough Blake supporters there. I think you could be onto something there for sure. But if you do go, I think there's a woman called MJ. She's a Blake supporter. She seems all right. I've had a little bit of communication with her. So I can put you in contact with her. But you could definitely hang out with her. I think you'd be safe. Oh my god, yes. I would love that. Okay, let's get back to the good part of this document. Right, Lively contends that the harassment also continued after filming. In particular, she claims that the Wayfarer parties planned, coordinated and implemented a smear campaign from California, which was intended to cast her in a false light, discredit her claims and damage her career. In addition, after Ms. Lively filed her CRD complaint in December 2024, another California-based act, defendants launched a second wave of retaliation executed in part through their California-based attorney, Brian Friedman, who made defamatory public statements and filed defendants' retaliatory counter lawsuit from California. Finally, Lively contends that her employment relationship was established through a contracting relationship between Wayfarer. It ends with us, Blakely Inc., all California entities negotiated in California through California-based representatives. You know, another thing I noticed about this document? I didn't notice one mention of Van Zan. Another total red herring in the comment section. In sum, she concludes that these facts show that the harassment on set was the foreseeable extension of a hostile environment conceived in California, directed by California executives, and perpetuated through California-based decisions, policies, and omissions. None of these acts or occurrences provides the substantial connection to California needed to sustain Lively's sexual harassment claims under FEHA and Section 51.9. Most notably, the acts do not implicate issue of core or ultimate wrongdoing having any bearing on the material elements of the cause of action. To start, many of the acts were not even taken by the Wayfarer parties and therefore do not involve conduct which gives rise to liability. The fact that non-party Judgement of Sony may have failed to act on complaints from Slate and Lively while in California cannot support a claim for harassment against the Wayfarer parties under California law, because there is no evidence that Judgement was acting on behalf of the Wayfarer parties or that she directed or ratified any discriminatory behavior. Unfortunately, no, she was acting on the interest of Sony Records? No, I guess it's Sony Movies. Anyway, they are probably not known for favouring the needs of women. Furthermore, the fact that Lively's counsel and representatives, Sony Pictures, sorry, my brain went dead for a minute. Sony Pictures are not known for their fair treatment of females. Furthermore, the fact that Lively's counsel and representatives negotiated her employment relationship while they were in California, or that Lively filed her CRD complaint in California, cannot support the application of California law. A plaintiff cannot transform an otherwise extraterritorial claim into territorial claim by the unilateral decision to challenge the defendant's conduct in California. Okay, so that's what extraterritorial means. Got it. Another new legal term I've learned. Nor do the Wayfarer parties own California-based acts established that the core of her claim arose from California. The vague assertion that Heath's private text messages to Baldoni about the birth of his child set the tone for harassment implicitly concedes that the conduct Lively has identified does not itself go to the core of her complaints. Now, this just shows you how unfair these laws are. In my opinion, no reasonable jury could conclude that Heath's text messages about being at home with his family bore a sufficient relation to the sexual harassment Lively claims to have later occurred on the set, or that Baldoni lashing out at a female producer in a pre-production Zoom meeting while in California has a substantial bearing on a material element of her claims. I very strongly disagree with that statement. Very strongly. I think it has everything to do with it. It shows a complete sense of male entitlement. Lively's efforts to invoke retaliatory acts taken in California as a basis for sustaining her sexual harassment claims are without merit. Lively asserts that under California law, retaliatory acts can constitute continuing harassment of an employee, and that because the retaliatory smear campaign was implemented from California, this means that her sexual harassment claims also involve California-based conduct. The court will separately address issues of extraterritoriality as they relate to Lively's retaliation claims. However, even if there might be some circumstances in which retaliatory acts exacerbate a hostile work environment and therefore qualify as a kind of continuing harassment, that is not the case here. The retaliatory smear campaign is alleged to have begun after Lively's working relationship with the Wayfarer parties concluded. The alleged acts of retaliation, therefore, plainly cannot support a hostile work environment claim. I mean, it just kind of doesn't really make sense, because it's hard to understand that if someone was prepared to launch a retaliatory smear campaign, that they wouldn't not be hostile at work. But again, this is the law. To the extent the complaint of conduct occurred after plaintiff's termination, the court fails to see how such conduct could create a hostile work environment for plaintiff, since he was... Oh, that was another case about Uber. Oh my gosh, how many of these poor employees have to sue these horrible companies? And these things drag on. Now you see why they drag on. Like the case against the Michael Jackson estate, that's been going on for 13 years. And it was finally meant to get to court this summer. I think it's been adjourned yet again. But they just haven't given up because they know they have a case. And the attorney who's I forget his name, but he's a bald-headed guy. I mean, that is his literal field of speciality is child abuse. He's been so patient and so thorough, like with every reapplication and wherever there's been a decision, he's managed to go back and taken the judge's ruling and then reapplied it to a new filing, and he's just done such a I can't think of another word for thorough, but like that's why that case hasn't gone away. Like, it is going to happen. It's going to happen. But the estate have done everything to block it from going ahead. Fastidious, that was the word I was thinking of. He's done such a fastidious job at every step that finally the court now sees that Michael Jackson estate is liable. Well, they have a case to plea that to make a complaint that the Michael Jackson estate is liable for Michael Jackson's conduct, basically, is what I was trying to say. Failing to hire additional HR personnel or to share HR policies with cast and crew was not the core of the alleged wrongful conduct underlying Lively's sexual harassment claims. To the extent Lively suggests that there may have been other California-based decisions, policies, and omissions responsible for her. Harassment. It literally says, responsible for her harassment. Courts are clear that formulaic recitations regarding California decision makers who instituted, approved, ratified, affirmed, and or implemented the discriminatory policies cannot provide a sufficient factual nexus. This case is therefore readily distinguishable from the ones upon which Lively relies. So they're arguing that the case that she cited doesn't apply to her. The remainder of the cases are further afield. That case is plainly inapplicable here, as there is neither allegation nor evidence that Heath or Baldoni concocted a plan from California to sexually harass Lively outside the state, nor is there any allegation or evidence that Lively was hired with knowledge that she would be sexually harassed by someone else outside of the state. I don't think they needed to concoct a plan. It was kind of like an unspoken decision that was going to happen. The remainder of the cases are further afield. In each, some ultimate act of discrimination central to the elements of the claim occurred in California. The court therefore grants judgment on counts 3 and 13 of the second amended complaint because those claims lack a sufficient nexus to California. That means that both Lively's federal and state claims alleging sexual harassment fail to survive the Wayfarer party's motions for summary judgment and judgment on the pleadings. So it's kind of really, really sad, that line right there. But that's what it boils down to. It's not that there wasn't a claim. It's they failed to survive the Wayfarer's motions for summary judgment because they didn't make a plan in California that there's any evidence of. And yeah, she can't pin them down to being in California? Well, we can get on to the retaliation claims. Lively's retaliation claims against It Ends With Us movie and Wayfarer under California Labor Code, and against It Ends With Us movie, Wayfarer, Nathan Tagg, and Abel under Federal Employment and Housing Act do not suffer from similar deficiencies. Finally, some good news. These claims involve Lively's allegation that the defendants subjected her to an adverse employment action by launching a coordinated campaign to cast her in a false light during the publicity and promotion of the film, to discredit her in the event that she publicly disclosed her concerns about harassment and other unlawful conduct, and to irreparably damage her career and future earning capabilities in direct retaliation for her participation in protected activity. Do you know what? I am still seeing comments today saying, she's never going to work again, her career's over. I don't think they're right. But I do think that her image has been really, really damaged by this unfairly. Whether these acts occurred and whether they amount to retaliation are not issues that the court must consider in connection with the issue of extraterritoriality. The only issue now is whether the core of the alleged wrongdoing possessed a sufficient nexus to California. It did. Lively alleges that in August 2024, Wayfarer retained California residents Tagg and Nathan to get ahead of Lively's grievances by planting false narratives portraying her as a bully and mean girl. Baldonian Heath, California residents, then directed the execution of this alleged retaliatory smear campaign over the weeks and months that followed on behalf of themselves and It Ends With Us and Wayfarer, also California residents. Lively further alleges that the Wayfarer parties launched a second wave of retaliation executed through their California-based attorney, Friedman, who made allegedly defamatory public statements and filed an allegedly retaliatory countersuit from California. The acts forming the basis of Lively's retaliation claims largely occurred in and were directed from California. The rule against extraterritoriality thus does not pose an obstacle. To the claims. Indeed, the Wayfarer parties offer no real fight here. Wow. They focus almost exclusively on the sexual harassment claims and state only with respect to the retaliation claims that Nathan and Abel cannot be liable for retaliation wherever it occurred. The court will address that argument at a later point. For now, Lively's 4th, 5th, and 7th courses of action survive. They drag on forever. This would bankrupt even a wealthy person. Right? And then people say, oh, they're just looking for a payout. Man, you just need to read the Epstein files, yeah? And see that a lot of those victims that received a payout, and I was watching Epstein, one of Epstein's lawyers' depositions, Darren Indyke. He looks like a toad, by the way. And it's actually a bit sickening because he's the executor of the estate, right? But yet he's claiming that he knew nothing about the abuse. He never saw any victims. He never saw anything untoward. Same as his accountant, and yet they're both the executors of his estate. And so they made it possible for victims to receive compensation from the estate. But when you actually break down how much they receive, it doesn't go that far. And they're making it an easy process. You know, because I mean, it's only been like a few years that they have opened up this avenue. And personally, I just question the ethics of the whole thing. I mean, their argument is that, well, no one knows the estate better than us. But at the same time, they stand to gain a lot for it. Although they both argued that they weren't getting any payment. The congressman, is it the congressman? The people that were questioning them, they didn't believe that. They were like, "There's no way you're doing this for nothing." And the other thing that was really interesting is that very early on in their careers, they became indebted to Epstein financially. So they're now kind of stuck into, they're never going to like turn on him. They're going to maintain they say it's abhorrent what he did. We want to be here for the victims, but at the same time, they don't want to implicate themselves. So they make a very good point of saying that they never saw, if they had any inkling that anything like that was going on, they would not have worked for him. But I do not believe it. I think that they had no other choice. They made it at some point early on in their lives, they made a moral decision that they were going to carry on working for him because he really looked after them. You think most of Hollywood is on her side. I think that good people, yeah. I think that good people are on her side. I think a lot of people must have respect for the fact that she actually stood up for this. Because I reckon this must happen on so many films that we would never hear about it. And even the fact of the judge saying, well, they didn't plan it in advance, so we can't really say it happened. Like, they didn't need to plan it in advance. It's just how they are. That's what I've been showing. And as to the people that say, oh, well, she was the one that launched a smear campaign. Like, I just went and looked at what he had said, the content that he had put out, and Jamie Heath. And then it became apparent to me that they have never hidden who they were as people. This is who they are. Anyway, I don't want to waffle on because we're getting to the good bit. Okay, Retaliation. Lively brings retaliation claims against Ends With Us movies and Wayfarer under Title VII, FIHA and California Labor Code Section 1102.5. She also brings aiding and abetting retaliation claims under FEHA against Nathan, Tag, and Abel. The court has granted judgment on the Title VII and Section 1102.5 claims on the grounds that Lively was an independent contractor. That's crazy. But anyway, that's what it says. However, a person does not need to be an employee to bring a retaliation claim under FEHA. Indeed, as previously explained, the Wayfarer parties have not moved for judgment on Lively's FEHA claims on the basis of her employment status. The court thus turns to Lively's retaliation claims under FEHA. In doing so, the court finds that there exist genuine issues of material fact requiring trial as to the claims against It Ends With Us and Wayfarer. Nathan and Abel, however, are entitled to summary judgment with respect to the aiding and abetting claims pleaded against them. The court withholds judgment with respect to Tag's liability for aiding and abetting retaliation. Before proceeding further, the court notes that the discussion below treats It Ends With Us movie and Wayfarer both as Lively's employer, not to suggest that there was an employer-employee relationship. There was not, but to conform to the language of the statute and case law, which use the term employer, even in cases involving independent contractors. You know what I was just thinking, is like, how is retaliation not sexual harassment? Anyway, what do I know? Lively has argued that It Ends With Us and Wayfarer were her joint employers under FEHA. The Wayfarer parties have responded that they never made any argument to the contrary, but that if they had, there would be reason to reject Lively's position. The court will not at this stage grant judgment in Wayfarer's favour based on a mythical argument that it expressly says it never made in its opening briefing. The court will therefore treat Wayfarer and It Ends With Us movie as joint employers under FEHA for present purposes. What's 22? Oh. The Wayfarer party's arguments regarding administrative exhaustion are deemed abandoned, as Lively argued in her opposition to the motion for judgment on the pleadings that, among other things, such an argument is an affirmative defence that they failed to plead and that they made no attempt to respond in their reply brief. Damn. As with the retaliation claims brought under Title VII, FEHA retaliation claims contain three elements. A plaintiff must establish: 1, she engaged in protected activity, complaining about sexual harassment; 2, the defendant subjected her to an adverse employment action; and 3, a causal link exists between the protected activity and the defendant's action. A causal link. The first part of the plaintiff's prima facie test, establishing protected activity, requires demonstrating that the plaintiff took steps to oppose practices forbidden. Put another way, a plaintiff may bring a retaliation claim where she has opposed conduct she reasonably believed to be discriminatory under FEHA, even when a court later determines the conduct was not actually prohibited. In a case where the court has not found an underlying FEHA violation, the question is the reasonableness of the plaintiff's belief that she was opposing a practice prohibited by the FEHA. This reasonableness inquiry contains both a subjective and objective component. A plaintiff must not only show that she subjectively believed that her employer was engaged in unlawful employment practices, but also that her belief was objectively reasonable in light of the facts and record presented. Blah, 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 blah. We're going to jump forward a bit. This is just citing other cases, by the way. Under FEHA, if the plaintiff, I thought it said the plaintiff. I thought it was going to say something, but it didn't. No, Abercrombie and Fitch. Okay, B, analysis. The complex issue of retaliation involves a factual inquiry into the employer's motivation and intent. Such inquiries are typically reserved for the fact finder and not to be resolved on summary judgment. There you go. Here, the court finds triable issues of fact with respect to all three elements of Lively's FEHA retaliation claim. Protected activity. The parties appear to agree that Lively engaged in at least some protected activity. Most notably, here it is, guys. On the 9th of November 2023, in anticipation of returning to set after the conclusion of the Writers Guild strikes, Lively's attorneys sent Messiaen, Wayfarer's in-house counsel, an email with the protections for return to production, the protections letter. Yeah, the 17 points that kicked this whole thing off back in December 2024. Lively's counsel stated that at this stage, this are the people at the back, our client is willing to forego a more formal HR process in favor of everyone returning to work and finishing the film if Wayfarer was willing to guarantee and observe 17 enumerated protections. For example, the letter stated, among other things, that an intimacy coordinator had to be on set whenever Lively was present, that there would be no spontaneous improvising of any scenes involving physical touching, simulated sex, or nudity. That physical touching and or comments about Lively's appearance had to be made only in connection with her character and scene work and not about her personally. That there would be no discussions of personal experiences with sex or nudity, and that no one would enter her trailer while she was in a state of undress. Why would they agree to this if they never did it? The protections letter further provided that there shall be no retaliation of any kind against BL for raising concerns about the conduct described in this letter or for these requirements. Any change in attitude, sarcasm, marginalization, or other negative behavior, blah, 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 as a result of these requests is retaliatory and unacceptable and will be met with immediate action. It's quite simple. And it required an all-hands meeting before returning to production to confirm and approve a plan for implementation of the above that will be adhered to for the physical and emotional safety of Lively, her employees, and all the cast and crew moving forward. On January 4th, the day before filming resumed, the parties held the all-hands meeting at Lively's home, attended by Baldoni, Heath, Giannetti, and producers Todd Black and Alex Sachs. Lively's husband, Reynolds, was also present. During the meeting, Lively read from her phone a list of behaviors that she had found inappropriate and that needed to change, including ones that could be considered related to sexual harassment. I would say this is an acknowledgement that sexual harassment had taken place, and it's still part of the lawsuit, from where I'm saying. No more discussions of personal experiences with sex and times that physical consent was not given in sexual acts. No more showing nude videos or images of women, including producer's wife, to BL and or her employees. No more mention of pornography addiction. No more improvising of kissing or biting or sucking of lip. No more intimate conversations out of character. No more personal physical touching of or sexual comments by Mr. Baldoni or Mr. Heath. No more jokes or disparaging comments. Do you know one of the things I've seen about this aspect of the case is people saying that she didn't have a problem with it or something? I mean, going by her behaviour. About HR complaints Wayfarer has already received on set or about missing the HR meeting. And no more entering, attempting to enter, interrupting, pressuring, or asking BL to enter her trailer or makeup trailer by Mr. Heath or Mr. Baldoni while she is nude for any reason. Lively asserts that she engaged in additional instances of protected activity, including her counsel's negotiation of contractual terms prohibiting sexual harassment from January through June 2024, her refusal to appear in promotion with Baldoni and Heath in August 2024, and the filing of her CRD complaint in this action in December 2024. The Wayfarer parties dispute that these actions constitute protected activity under FEHA. The date of Lively's last instance of protected activity is relevant insofar as a short amount of time between such activity and an adverse employment action can raise an interference of causation. The court need not resolve this dispute. Lively's complaints made via the protections letter and during the all-hands meeting satisfy the elements of protected activity, and as further explained below, there is enough evidence that this activity was a substantial motivating factor in any adverse employment actions to survive summary judgment. I don't know whether the stuff about, because it was like the minute that meeting happened, that was when he was on the group chat, he was on the phone to Stephanie Jones, he was on he was on the attack, he was in paranoid mode, he was in full attack mode. And yeah, I don't think that's all going to go down too well with a jury. A reasonable jury could conclude that Lively opposed practices that she subjectively believed constituted sexual harassment by complaining about inappropriate behavior in the protections letter and during the all-hands meeting. That doesn't, to me, look like she lied about sexual harassment or made false claims. The Wayfarer parties have not specifically contested Lively's subjective belief that she was discriminated against, and there is sufficient evidence suggesting that she felt she had been. During the first week of filming, she complained privately to a friend that it's like HR nuts today, the both of them. I wasn't expecting that turn. I mean, it's been present, but today I came home and cried. They're just being creeps. Like, keep your hormones to yourself. This is not mine. I don't want it. I don't want you gaze or words or tongue or videos of your naked wife. Yeah, it's shocking. Lively also privately indicated that she was dreading returning to production because of her experience during the first phase of filming. Does that sound like a lie? They love holding up her conversation with Sklenna like the situation is equivalent when Sklenna never complained about Libby. Look, some of the instances I've seen, like comparing her to, like I've seen people say, well, in this movie she dressed like this, she did this in this movie. It's like, if you're acting in a movie, you're being directed to do stuff, first of all. Second of all, I'm sure I said this at the very start. What official complaints have been made against her ever? At the very start, Justin Baldoni sent that text message saying this is what we would need. Examples of bullying. What did they drag up? Shusty Floor. We're going to get onto Shusty Floor in a minute. That was all they could drag up in her entire career. This woman has worked since she was a teenager. And then like some weird woman that said she sold her clothes on her website, which looked to me totally fake. Who else? Then it was like one of the ex-cast members who just happens to be a Baha'i said something negative. And then one of the female actresses, which I don't think ever's like been verified. It was just a rumor. She got a makeup artist fired, but he was using his bare fingers to apply lipstick and taking photos of her sleeping. Yeah, I mean, where's his TikToks then? Like, and also, I'm not being funny, yeah, but celebrities have haters, you know, it's kind of normal. But this was on a whole different level. The people that were saying that stuff, they didn't even really know her. The only person that claimed to know her was Salty Lynn. Sweet and Salty Lynn. And then it turns out that Sweet and Salty Lynn is basically trying to be an influencer. And she went to the same school as her, but was like 3 years apart. The Shusty Floor of it all. Right, let's get back to Shusty. Shusty. I just think, like, for these people that are saying she lied, like, how are you going to send those text messages? You know, remember this woman's got 4 kids now. She's juggling. She's going to the gym. She's trying to work out to lose weight, to look good. That they're going to get onto that as well. The fat shaming thing, which again, I don't necessarily agree with it. I mean, it is what it is, but they argue that because they recognize that they have to look a certain way in these movies, that's not really fat shaming. But anyway, what I'm trying to say is She had so much going on. You think she's going to be sitting there making up these text messages to her friend, crying about what a horrible day she's had? Not in the real world. Baldoni himself made statements suggesting he understood Lively made her complaints in good faith. He stated, "I just know her personality, and this is the kind of person that genuinely believes she's right and that all of this is unjust." To which Nathan responded, "She fully does, I know it." Along similar lines, Baldoni told friends, "It's hard to feel so much of what they believe about me as false because they are so convinced that it's real. We were told this was the worst experience of her life." "I came home and cried. They're just being creeps." Sounds pretty bad. To be sure, the Wayfarer parties have suggested that Lively used her experience on set as a cudgel for control of the film. That's another thing I wanted to say earlier as well. It's like this whole argument as well, it doesn't pan out in this court ruling. There's nothing about it. There's nothing about her taking control. There's a lot about how her and her team tried to stand up for getting her full rights to not have to be harassed and the other stuff, but nothing about taking control that I saw, unless I missed it. And these people are like, "Oh, well, do we have any evidence yet?" I don't know what else you're waiting for. To be sure, the Wayfarer parties have suggested that Lively used her experience on set as a cudgel for control over the film. He's stating that she continues to hold a threat over our heads, and every time we try and hold a line, she uses that threat either directly or indirectly to get us to fold. What are you talking about, bruv? I'm so over them. I just want this trial to happen, honestly. Baldoni stating that the protections were sent in an effort to gain power over him personally and the studio. But a reasonable jury could find, let's hope it is a reasonable jury, could find that Lively also genuinely experienced what happened on set as discriminatory. So it says it right there. A reasonable jury could find that Lively also genuinely experienced what happened on set as discriminatory. But because she was an independent contractor, it's assumed that she's not discriminated against. That's an F up in the law. The two are not mutually exclusive. There is at least a triable issue with respect to whether Lively sincerely experienced what happened on set as sexually harassing. So they're not even saying she has to argue that it's sexual harassment. It's whether she experienced it as that, which clearly she did. I don't care what any of these haters or idiots or women haters, they've come into my chat and called me a man hater. You hate women then, obviously. Viewed in the light most favorable to Lively, there is also sufficient evidence that it was reasonable for her to believe that the Wayfarer parties sexually harassed her by creating a hostile work environment. There is also sufficient evidence that it was reasonable for her to believe that the Wayfarer parties sexually harassed her by creating a hostile work environment. I wish this bit had been at the beginning. In analysing this issue, the court need not and does not determine whether the relevant conduct rose to the level of sexual harassment. The question is instead whether Lively's belief was, as some courts have put it, utterly baseless. Was it utterly baseless? There is enough evidence in the record to conclude that it was far from baseless. Hostile work environment claims under FEHA operate under the same guiding principles as those under Title VII. Courts must also consider that the real social impact of workplace behavior often depends on a constellation, that's a galaxy, of surrounding circumstances, expectations, and relationships which are not fully captured by a simple recitation of the words used or the physical act performed. This is a bit more like it. The relevant conduct must be discriminatory. Lively has identified a series of acts that she claims created a hostile work environment based on her gender, beginning with her work on the film and continuing through the conclusion of the first phase of filming. Several of the incidents either would not support a hostile work environment claim or would do so at most only minimally or in context. Other incidents come closer to stating a claim. The court begins with the former before turning to the latter. When viewed together, the incidents are sufficient to support a reasonable basis for Lively's complaints and therefore her assertion of a retaliation claim. When Lively first met with Baldoni in December 2022 to discuss possibly participating in the film, Baldoni told Lively, who was pregnant with her first boy at the time, that he was circumcised. Lively found the disclosure uncomfortable and unnecessary. But it occurred in the context of a discussion about the different medical decisions people make these days, including circumcision for male babies, a topic that Lively may herself have introduced. More importantly, it occurred before she began working on the film. It therefore could have not created a hostile work environment. Any incidents giving rise to the hostile work environment claim must have occurred during the plaintiff's employment. I mean, fair enough, but in my opinion, he was definitely testing her boundaries with that, or basically showing his lack of apparent awareness of other people's boundaries. That's just my personal take. I don't think I'm alone. You know, people who went from never once thinking about Blake Lively to absolute hating her overnight. I know, right? I mean, some of the comments I see, I'm like, she's that important to you? It's really bizarre. I just feel like she's just one of those people that's just kind of like inoffensive. Like, she's not always like getting involved in drama stuff. She's not always like poking her nose and stuff like so many other celebrities. I don't necessarily approve of some of the work she does. It's just so not my bag. But I've never really noticed her to be someone that looks for that kind of negative attention that this whole saga has warranted her. That is just my own personal view on it. And then the other thing I don't get, is if they think she's such a mean girl and bully that needs to be brought down, why do they support creators that literally demonstrate those characteristics every day of making their videos? Whether it's on TikTok or YouTube. or whatever else. Blake Lively is the reason my father left me and my mother is an alcoholic. I think it's called parasocial relationships. It really is, to be that invested. The hatred, like especially Reddit, has got to be the worst. Actually, those people do not sleep. They don't rest. The minute this thing was uploaded, there was about 5 posts within the first hour about it, saying, like I said, we told you. I'm like, you didn't tell me. You didn't tell me any of this. Okay. Oh my God, this is a really X-rated bit. Other conduct, particularly viewed in isolation, also would not give rise to a claim for hostile work environment. Prior to principal filming, Baldoni proposed certain edits to the screenplay, including ones related to sex that Lively believed were gratuitous. There was one that was mentioned at the hearing, which I had not even heard about, where he apparently wanted her to crawl across the floor to go down on him. Baldoni suggested scenes involving sexual acts in the context of developing a motion picture involving such adult themes did not create a sexually objectionable environment or an environment hostile to women or men because of sex. It would be neither surprising nor unreasonable from a creative standpoint for both Baldoni and Lively to have drafted sexually explicit material, even if some of it was not to the taste of the other. Okay. Not according to the conversations that were had with Colleen Hoover. She said it was best left for the audience to imagine it. If I remember correctly. Indeed, Giannetti had written to Baldoni that Sony was going to try and get as much tasteful hot sex as you can. As the court observed in I don't know where that sentence leaves. In a similar principle applies here with respect to the creation of the screenplay. Yeah, okay, whatever. I think the word we're looking for here is nuance. I guess that doesn't apply to court cases. I do remember this being discussed in the hearing. But yeah, I mean, the research and the kind of context that we've seen with regards to that issue is Baldoni was looking to put more sex into the movie. I think that was his call, but yet he wanted to say that that was coming from women. And yet the women around him was saying, that's not really what we're feeling. And more importantly, they wanted a teenage applicable rating so that more people would see the movie, which basically his idea being that this is supposed to improve people's lives and reach more people. Why would you do that if you want an X-rated movie? Which basically, let's be honest, is going to appeal to more of a male demographic. Lively's complaint of fat shaming also could not reasonably support a claim. Shortly before work on the film began, Lively gave birth to a child. She expressed to Baldoni that she wanted to be in her best shape for filming. On or around April 23rd, 2023, before principal photography began, Baldoni asked a personal trainer he had consulted with and who was working separately with Lively if the trainer knew what Lively would weigh when filming began. Baldoni's question then found its way back to Lively, who felt disturbed and unsettled that Baldoni was soliciting information about her weight. On another occasion, Baldoni introduced Lively to a specialist in probiotics, who Lively subsequently discovered also specialized in weight loss. So, I mean, again, this is such a personal issue, but I don't know really one woman on earth who has not, in one point in their life, had some kind of anxiety or insecurity about their body, mainly because they are constantly judged for their bodies, like literally wherever you turn. In certain countries, may I just add, and certain cultures. I know that there are people that live outside of entertainment culture and probably don't even have to think about that stuff, and they're probably much happier for it. So yeah, I'm going to, and also, like, another thing I was going to say is this was an issue in the Epstein files as well. Epstein was constantly nagging all of his girlfriends and all of the females that he was in contact with, some of whom he trafficked, some of them that he was proposing to traffic, about their weight and that they should lose weight and that they shouldn't eat, and that gave them a complex about their weight. I don't think it's a good thing at all. Like, you can say it's part of the film process, but it's still, to me, it's part of like coercive and gender biased behavior. I think they should maybe change the law at some point. I don't know. Evidence that an employer made... Oh, sorry, I just read that. Oh, yeah, I did. No, I didn't read that. Evidence that an employer made weight-related comments to persons of only one gender could, in certain circumstances, help demonstrate a hostile work environment based on sex. Although the record here does not indicate whether any similar conduct was directed toward men, regardless, the conduct cannot reasonably be viewed as expressing hostility to Lively as a woman or to women in general. Yeah, but is he going to go and do that to a man? Really? He's going to go and ask a man's trainer how much he weighed? I don't believe it. The physical appearance of the protagonists was part of the product that the producer was intending to offer the audience. Yeah. The physical appearance of the protagonists was part of the product that the producers were intending to offer the audience. That's true. But she had that. She had that. She's under enough pressure as it is without him just overstepping a boundary. There was just no need for it. And it just seems like the court hasn't really recognized that. Maybe a jury will. Lively herself recognized that achieving a certain aesthetic was part of the job that we were both excitedly signed up for. She asked Baldoni if they could do the body scenes at the end of the schedule so that she would have sufficient time to work out. She wrote to her agent privately that she was working out twice a day, 4 hours a day, in order to lose weight and set the movie up for success. That's crazy. As the sexiness in this film and the marketing, I'm sure, is critical to its success. And she told Baldoni, "My husband and I both look at certain roles as athletic events, and this is one of them." And that's great. Given these statements, Baldoni's actions, even if they could be viewed as gently pushing Lively to lose weight, which is not necessarily gently pushing. What about his meltdown about the wardrobe because the paparazzi photos said she looked old and frumpy? That's not gently pushing. Which is not necessarily supported by the evidence, could not fairly be described as discrimination because of Lively's gender. Okay, court, whatever. Lively also points to certain conduct that occurred during filming. Early in the production phase, Lively and Baldoni filmed a scene in which their characters danced together. We've seen it. It was unscripted. The script stated that their characters would be slow dancing completely in their own world, but did not otherwise include details about how the scene would be shot or how the characters would be interacting. The script did not specifically call for any kissing or simulated intimacy. Wasn't it meant to be just like a kind of transition shot of a few seconds? Yet Lively claims that during filming, Baldoni leaned in and gestured as if he was intending to kiss her, and that he kissed her forehead, rubbed his face and mouth against her neck, put his thumb to her mouth and flicked her lower lip, caressed her and leaned into her neck saying it smells good. We've seen it. Lively, Declaration 19. The record includes videos of the scene. The scene was shot in front of a large group of people, so what are they going to say? Baldoni can be heard giving blocking instructions. Both actors can be shown improvising. Other actors are in the background. Okay, but she was definitely... This was on... Wasn't it on day 1 or 2? And she was 100% in her body language, looking very uncomfortable and telling him we should just be talking rather than doing anything else. And I remember she said something about red flags because she was trying to be the part and saying like that would be a red flag. Both actors can be shown improvising. Other actors are in the background. There is no question that this conduct might support a hostile work environment claim if it occurred on the factory floor or in the executive suite. But in all sexual harassment cases, the court must consider the social context in which particular behavior occurs and is experienced by its target. What is the point of having an intimacy coordinator then? What is the point of having SAG rules and union rules and other protections if you're just going to say that? And I remember Judge Lehman asking about that at the hearing and saying, well, is it acceptable to touch her back or how does it work? And the attorney said there has to be consent. And basically, she did not give consent for that scene, is what the argument is. The question is whether in this context, Baldoni's conduct could reasonably be understood to reflect a view about Lively as a woman rather than the role she was asked to play. Under this framing, it would be difficult to view Baldoni's conduct as reflecting hostility or bias based on gender. He was acting in the scene. Assuming he was improvising, the conduct was not so far beyond what might reasonably be expected to take place between two characters during a slow dancing scene, such that an inference of hostile treatment on the basis of sex would arise. At least in isolation, the conduct was directed to Lively's character rather than to Lively herself. Are you sure about that? I'm not sure I agree with this. Creative artists, no less than comedy room writers, must have some amount of space to experiment within the bounds of an agreed script without fear of being liable for sexual harassment. Oh, gosh. Okay. Although these incidents could not on their own sustain a hostile work environment claim, sexual harassment claims must be viewed based on the totality of the circumstances. And there is other conduct by defendants that presents a closer question. A reasonable jury could conclude that Baldoni commented on Lively's and Slate's personal physical appearances rather than their appearances as actors or characters in ways that made them made them uncomfortable. Comments of these types can help contribute to a hostile work environment. Change the law. I'm gonna start doing protests. No, I'm not. Definitely not. But it is worth thinking about, though, you know. This law is very in favor of a man's perspective. Because the point is, it's small acts together that contribute to a hostile working environment. And I feel like that was a power play. Like, he was like asserting his power over her in that moment. But I don't know. I don't know if it's going to be made a big deal of. They may think it's not a good idea to focus on it because of the way people interpret that scene. Might be held against her. So I guess it depends on your own personal perspective. So then we've got the bit about he asked her to remove her jacket and reveal her partially unzipped onesie with the lace bra, and he stated pretty hot in a tone that made her feel on display and uncomfortable, and that was not what she was going for. And he replied sexy, to which she stated neither. The comment was understood contemporaneously to be inappropriate. I mean, I guess maybe just thinking, because like, what's his name? Judge Lehman's brother is a film director, isn't he? Maybe he's like, yeah, maybe I better not step into like, maybe I better not tread on the film director role's toes too much with my ruling. I don't know, but I just kind of feel like it doesn't really sit well with me, that one. If we're supposed to be protecting people with these laws and justice processes. Slate told Baldoni that comments about actors' bodies and their wardrobes ranged from irrelevant or unnecessary to inappropriate and distracting, and we're just not doing this anymore. Baldoni rolled his eyes and stated, sorry, I missed the sexual harassment training, before walking away. Also that day, Lively was wearing a jacket over a dress with a lower cut neckline, not in the wardrobe, and when she went down to pick something up, her jacket fell open, revealing her dress and cleavage, and Baldoni said, I like your outfit, while making a back and forth gesture across his chest area, which Lively interpreted as referring to her chest. Although Lively had referred to her own wardrobe as sexy on certain occasions, that did not open the door to all manner of comments on her appearance. Baldoni also told Slate, who played his character's sister, was not involved in any sexual content in the film and was wearing black leather pants at the time. I can say this because my wife is here, but you look sexy in what you're wearing. Then there is the intrusion into Lively's physical privacy. On the second day of filming, Heath arrived at Lively's trailer while she was almost entirely undressed and having her body makeup removed. So I've been over that one in quite great detail. The Second Circuit has recognized that stares at a woman's body can provide evidence of a hostile work environment. And thank God for that. And here, Lively was in a state of undress and specifically asked Heath not to look at her. In another incident, Baldoni and Heath pushed for Lively to perform a birth scene naked, even though her character was in a hospital. The thing is, as well, it's the timing of this, because that was on the first day, wasn't it? It was on the first or second day before she had signed the nudity rider, because she wasn't supposed to be nude. And they slipped that one in. Even though her character was in a hospital, they had not previously discussed blocking the scene in this way. She had not anticipated or agreed to be exposed in the scene, and the offer letter provided that there would be no nudity, simulated sex without artist's prior written consent, and negotiation execution of a nudity rider. Lively felt forced to compromise by performing simulated nudity from below the chest down, with her uncovered legs spread apart, wide in stirrups, and only a small thin piece of black fabric covering her genitalia. For the entirety of filming, the scene, which took several hours, the set was not closed to non-essential personnel. Lively has submitted some evidence that industry standards would call for an intimacy coordinator to be present because there was implied nudity and a high hip exposure that constitutes profile nudity, but no such person was present. So I've seen that point argued on Reddit, where they've put up a picture of it and said, this doesn't constitute nudity. At another point during work on screenplay and in discussing a sex scene in the film, Baldoni offered that he and his wife orgasm at the same time, and he asked if Lively and her husband do the same. Also during the writing process, after Lively commented that she believed some scenes had become somewhat pornographic, Baldoni volunteered that he had previously been addicted to pornography. Lively stated that she had never seen it, and Baldoni later announced to individuals on set that she'd never seen porn. It may be fair grounds for an author or a director to discuss personal experiences, including those related to sex, as part of the creative process. Huh? How is that part of the creative process? And the mere mention of sexual content or topics in the workplace does not necessarily support a hostile work environment claim. But Baldoni's on-set comment to crew members regarding whether Lively watched porn bore no apparent connection to the creative process and singled Lively out in front of others in a way that could be interpreted as relating to sex based on gender. There are other instances of alleged inappropriate behaviour, including one in which Heath showed Lively a video of his wife giving birth, and that, again, another huge talking point. But while she was having lunch, by the way, the day after she'd filmed the birthing scene, and she's also given birth to 4 kids of her own, but it suffices for present purposes to conclude that, drawing all inferences in Lively's favour, a person in her position could have understood the workplace to at times reflect a gendered and sexualized view of women and a disregard for their privacy, sufficient to make it reasonable to complain about a hostile work environment based on sex or gender. That conclusion finds additional support in the fact that Lively alluded to many of these incidents in the protections letter, and the Wayfarer parties wrote that although their perspective differs in many aspects, they found most of her requests not only reasonable, but also essential for the benefit of all parties involved. The court need not consider whether the acts, as alleged, would support a jury verdict that the Wayfarer parties created a hostile work environment under FEHA. It is sufficient that it was reasonable for Lively to believe that they did. Oh, even if a plaintiff beliefs regarding sexual harassment are legally mistaken under FEHA, a retaliation claim might be sustained where the nature of the complaint reasonably falls within the statute's general purview. Finally, a jury could also find that the Wayfarer parties understood that Lively thought they had behaved in a discriminatory manner. Baldoni stated with respect to the protections letter, of course, we all know what this document insinuates, that I am unsafe, sexually harassing, etc., etc., etc. The word creepy and abuse were used in reference to me and my behavior. When Slate called Baldoni out on set for remarking on Lively's appearance, he stated, sorry, I missed the sexual harassment training. There is enough evidence. I'm not reading all of it because we've gone over this a million times. There is enough evidence to bring the issue of Lively's protected activity before a jury. Adverse employment action. There are also tribal issues. I just hope to God they get some women that actually have some kind of like value in themselves autonomously from men on this jury. Is that a good way of putting it? There are also tribal issues with respect to whether the Wayfarer parties took any adverse employment action against Lively. The main way in which Lively believes the Wayfarer parties retaliated against her is by concocting and executing a multi-tiered social manipulation plan to destroy her reputation. That allegation represents the crux of her case. So the court outlines it here in some detail. Well, we know all about that. And I still can't get over the fact that this comes down to in May 2024 after Reynolds blocked Baldoni on social media. Baldoni worried that Lively might do the same to plant seeds and give crumbs so that fans would go digging. He therefore asked his publicist Jennifer Abel to formulate a real plan in case that happened so that he could feel at ease. You know what I was thinking about as well is like, as soon as this summary judgment order was uploaded, they must have, the media must have been sent out something at exactly the same time, because I think the Daily Mail, the Mail Online, were one of the first to put out an article about it, which wasn't very positive towards Blake Lively. And then I was remembering, like, right at the beginning when Jen Abel was saying about one of her really good friends, her best friend, who worked for People, the Mail, and another one, was it US Weekly? And she hated Blake Lively. And I'm like, that's why you see these headlines. It's not because of what's happened. It's because there's genuinely people that have a vendetta against Blake Lively in the media. So basically, this part of the argument is about whether he was within his rights to engage the crisis PR to protect his image. And by the crisis PR, I'm talking about Melissa Nathan. So they've got a quote there, which was sent by Lively and her team per our conversation. Abel asked Heath to share with her the legal letter that was sent by Lively with her team. So that's the 17 points. Yeah. So they were obviously, that was their cornerstone for the campaign, was to take every single one of those points and try and discredit it. That would be helpful to arm us in case we need to refute any of the claims. Abel recommended Melissa Nathan and her firm TAG for the crisis communications role. Nathan and TAG Vice President Catherine Case met with Heath and Hanks for an introductory call. Katie Case was like, we should never have taken this. So then we've got, yeah, there it is. Abel texted Heath and Topshavich that confidentially, this is on 31st July 2024, confidentially she was out to dinner with a friend of 12 years who writes for People, Fox News, In Touch, and US Weekly. Okay, I got my tabloids a bit mixed up, but still. I bet one of them works for the Mail as well. She is, and then there's TMZ. So what's her name? Melissa Nathan has TMZ and the Mail covered, and she has People, Fox, and In Touch, and US Weekly. So once you have that lot, the rest just fall into place. And then there's that guy, Matt Baloney. I was actually looking on LinkedIn today. I've just been looking on LinkedIn a lot lately, just for some other, nothing to do with this. But I was like, let me just out of interest see if anyone's talking about Blake Lively, because I've noticed that like YouTube content has started spilling over onto LinkedIn. And so guess what I found? I found a post by one of the founders of that Puck newsletter. Yeah? And he had actually posted messages between Melissa Nathan and James Vatushka saying she should, where she was saying he should sign up for it. He was saying it like it was a good thing. And he openly hates Blake Lively's publicist. For what reason, I have no idea. And Stephanie Jones. But yeah, so he's another one that writes negative articles with very little prompting. So she's fully briefed on the situation and is armed and ready to take the story of Blake weaponizing feminism. Well, I still have yet to see that. If anyone was weaponizing feminism, it was Justin Baldoni. To any of her outlets, the minute we give her the green light, she hates Blake, has heard this story before, and will do anything for us. On August, what? That she stands up for herself on set? Wow. On August 1st, 2024, TAG discussed drafting a scenario document in anticipation of an inevitable story from Lively's team in order to sensationalize Lively's story by teeing up a friendly to run the day or night after the premiere. Someone who's covering the overall film of Baldoni saying something along the lines of, me and Blake had our differences, but I still respect her. So we at least set the stage and can give them the rest on background to reporters. Blah, 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 blah. Okay, we don't need to go over all this again. But that was the scenario planning. Minutes after receiving the document, Baldoni said he wasn't happy about that. Not sure I'm feeling the protection I felt on the call. Then we get the he wants to feel like she can be buried. Then we get the Hailey Bieber, this is what we would need text. So just to repeat one more time, to hear this read out in the court, I don't know how it's going to go down. Nathan responded, of course, but you know, when we send over documents, we can't send over the work we will or could do, because that could get us in a lot of trouble. She said it right there. She added, we can't write it down to him. We can't write, we will destroy her. Then we've got the reckless thoughts of wanting to plant stories. Nathan said she'd already, off the record, spoke to her friend of the Daily Mail. Ready when we are. Then we've got the quotations for 175 a month. For 3 months, or 30k a month it was. Blah, 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 blah. I'm not going to go through all this again. I do have videos that I made at the time about it. Got some more comments. You don't think Justin was that upset about the blocking until Melissa planted the seeds in his mind that she was doing some kind of... I don't know, because... Yeah, I mean, he did message Jennifer Abel about it. I'm surprised that they didn't unfollow him a long time ago, to be honest. I'm surprised they actually followed him in the first place. I suppose they have to as part of the contractual agreement. But I think after the behavior at his apartment, Ryan Reynolds just surely must have seen a big red flag with him by that point. Baloney seems shameless. Who puts what on LinkedIn? I know. I mean, the comments was like, it had a few comments, but it was nothing like LinkedIn is such a like dystopia. You can't say anything on there that's vaguely intelligent. I feel like everyone's like a zombie. It's like, oh yeah, that's such a great point. Yeah, well said. It really is. Sometimes I have my little moments of like joking, trolling, but because I do it in a sarcastic way. Like I'm like, oh my God, yeah, I totally agree with you. And I'm obviously don't totally agree with it, but I'm having to really behave myself on there. So I'm having to keep a professional facade going. I mean, I do not think that they just unfollowed him at that point. I think this was like, I mean, can you imagine? She's coming home crying, and then she's had all this shit going on, and then it's like, imagine having to see his posts of him kissing his wife and all the other bullshit he puts up on there, like knowing he's a total fake and talking about being in his wound. I just personally wouldn't have been able to put up with that. But I think Blake Lively is very tolerant compared to me in that respect. Right, let me look at my notes again, because I feel like I've gotten a bit too into this document now. Okay, we've got the expert reports that supported her allegations that there was an online campaign to manipulate public opinion and discussion against her. I haven't been through that. I have got it set aside to do a deep dive at some point if I get around to it. Professor Culotta found statistically significant and practically significant deviations from expected values for top comments on TikTok, expressing both negative sentiment towards Lively and positive sentiment towards Baldoni. Nearly all of the top comments with the highest top comment share in the period starting August 2024 either disparage Lively or praise Baldoni. Moreover, among the most unusual top comments were ones on posts that the Wayfarer parties internally discussed in text messages. Professor Culotta also found multiple extreme statistical outliers in comment score patterns on Reddit, which pointed strongly toward a coordinated campaign. Professor Culotta concluded that although the Wayfarer parties stated that their campaign would be untraceable, there were clear online markers of inauthenticity suggesting a manipulation campaign. Wow, you don't say. Now let's get to the digital campaign allegedly executed by Wallace from May 1st, 2024 through July 2025, TAG communicated directly with certain individuals who seed, generate, create, or influence social media content or provide related digital services, including Billy Bush, Andy Signal. I was wondering what's happening with his appeal. Candace Owens, Perez Hilton, and Sage Steele. Sage Steele, there's a whole email with the talking points, and that Steve Sarowitz is copied on, where he's copied in that guy that does pro-Israel propaganda astroturf thing. For example, Nathan messaged Hilton that he was in her circle of BF trust. I thought she thought he was like a troll that no one listens to. That no one's paid any attention to since 2005. She's so two-faced, that woman. And that she would be happy for him to say this. And you can say, with Hilton responding, we'll get on these later. I want to know what she said to Andy Signal. Oh yeah, she sent her first Sage Steele shared her first draft of the video to Sarowitz, who replied, "It was a good start," and asked Sarowitz, Mr. I don't get involved in the day-to-day. Asked whether she would point out that other women were hurt by Blake, including the assistant director and editors and the wives of the men Blake falsely accused? Damn, Steve. Steele responded that she could add many women who were part of the production, but that she was not sure she could go too much deeper there based on trying to make it look organic. Like she doesn't have too much insider info. Steele subsequently posted a video titled "Shame on Blake Lively." TAG also indicates that it has communicated. Someone needs to make a video about that, actually. I doubt if any of Sage Steele's audience even knows about this. TAG also indicates that it has communicated about Lively and Reynolds with approximately 20 media outlets, including the Daily Mail, People, US Weekly, and Deux Mois. Yeah, well, we know all about this. We know about Alison Boshoff. Is it Boshoff? Professor Ashley Humphreys, a professor of integrated marketing communications at Medill School of Journalism and professor of marketing at the Kellogg School of Management at Northwestern University, calculates a conservative estimate of over 176 million online impressions calling Lively a bully, mean girl, and tone deaf. Damn. in the wake of the digital campaign. That is a crazy amount. Polling from between June and September 2024 indicates a 30% increase in negative attitudes towards Lively. Professor Humphreys determined that the Retaliation campaign promoted specific identifiable frames associated with Ms. Lively, and these became widely circulated during and after the period of the campaign. They became the lens through which the general public integrated new information and had a lasting negative impact on Ms. Lively's reputation. Yeah. She was, when it was first announced that she was cast in the role of Lily Bloom, the novel It Ends With Us went back to the #1 seller on Amazon. And at the time, Baldoni believed that she had a sterling reputation and was well liked by fans. Oh dear. Since the film's release, Lively has instead suffered a marked decrease in interest in her acting services, and she has received no meaningful or real offers. Damn, I thought she was still doing stuff. That's so sad. I mean, he hasn't got any either. But I thought she still had projects lined up. The Wayfarer parties argue that they took no adverse employment action against Lively and that their actions were instead reasonably intended to protect themselves and their reputations from unfair and false attacks. Lively responds that they engaged in a coordinated attempt to attack her character and destroy her reputation in ways extending beyond mere reasonable defensive measures. At this stage, the court need not and may not pass on whose account is more credible. The question is whether Lively has provided more than a mere scintilla of evidence. Remember when one of, well, you probably don't remember, but during the January hearing, one of Baldoni's attorneys said it was down to a few likes on social media. That was how he tried to frame it. A mere scintilla of evidence support her claim such that a reasonable jury viewing the evidence in her favour could find that the Wayfarer parties took adverse employment action against her because of her protected activities. I would say there's more than a mere scintilla there. So then they talk about how it's normal to engage with crisis management to protect people, to protect their reputations. A reasonable employee in a public-facing industry would not expect an employer to refrain from hiring crisis communications professionals to be protected against negative attacks. But it's not negative attacks, is it? It's having the truth about something bad you've done being revealed. The Wayfarer parties were also entitled to prepare responses to the protections letter and to the accusations that it implied. Furthermore, Lively has cited no support for the proposition that a person publicly accused of serious misconduct cannot use proxies, both disclosed and undisclosed, to defend him or herself. For example, it was permissible for Baldoni to request that the digital team boost certain videos which he believed were favourable to his image. and for Tag to work behind the scenes to emphasize his stellar reputation among colleagues and industry peers, including the fact that he was a long-time activist and advocate for women in Hollywood. If anyone still believes that, and to tone down inflammatory allegations against him, the Wayfarer parties similarly would have been within their rights in elevating stories that would cast doubt on whether Lively was a credible reporter of the events that occurred on set. However, certain conduct, at least arguably, crossed the line and is sufficient to preclude summary judgment. There are limits to the response that the accused can make in response to claims of harassment. There comes a point where the accused stops simply defending him or herself and starts taking action that a reasonable jury could view as retaliation for the fact that the accuser had the temerity to make the accusation. There is an important difference between defending oneself on the one hand and threatening, intimidating, or otherwise interfering with someone's right to pursue a discrimination claim on the other. The Wayfarer parties planned a public relations campaign that included as a key messaging point the fact that Lively had a less than favourable reputation in the industry spanning decades, and that production members lost their jobs due to her takeover. There is evidence from which a jury could find that the Wayfarer parties planned more aggressive action not only to destroy Lively's accusations, but to destroy her and her career. Nathan told Abel, among other things, you know, when we send over documents, we can't send over the work we will or could do because that could get us in a lot of trouble. We can't write, we will destroy her. They've put that in twice just to hammer home the point that they had an intention to destroy her. It's very, very clear. Then we've got the quote from Sarowitz. That he stated, there'll be 2 dead bodies when I'm done, you know, and so not dead, but you know, but you're dead to me. So that kind of dead, but dead to a lot of people. The Wayfarer parties assert that even if they contemplated taking offensive action against Lively, they never ended up doing so. But a jury is permitted to infer that when a party plans after deliberation to take certain action, the party has engaged in that action. It is fair to presume that the Wayfarer parties did what they said they had planned to do. There is also some direct evidence that the plan to destroy Lively and her career was put into action. In addition to boosting videos of himself, Baldoni requested that the digital team amplify a video criticizing Lively as insensitive to domestic violence survivors. There is also evidence suggesting that Tag sent to Jed the Little Bump video and a Daily Mail article entitled Hollywood Villain, which branded Lively a mean girl. These are 2 examples of what Case described as Jed and his team's effort to shift the narrative towards shining a spotlight on Blake and Ryan. So, in other words, Shisty became popular because of Jed boosting her video. which is what most of us pretty much suspected. She wants to think it's because she's a journalist exposing Hollywood. Isn't that what Sloan says as well? Yeah, Sloan was actually involved in the smear campaign. I think he's kind of stopped now because this is a bit too much work for him to actually follow a court case. Okay, let's jump ahead. The final element of Lively's case, establishing that her protective activity was a substantial motivating factor in an adverse employment action, presents yet more issues of fact for the jury. Okay, so these are all things he's saying that have to be decided by a jury. But Wayfarer wanted him to make a summary judgment without considering that they're not statements of fact. The question of what motivated an employer's desire to engage in the alleged retaliatory conduct is a quintessential jury function. So I'm going to jump ahead. To be sure, a jury could also find that something other than retaliation explains the actions of the Wayfarer parties, as they argue they had a legitimate interest in protecting their reputations and the reception of their film. Yeah, but she never did anything to damage the film. Or do any negative press. So they're going to have a hard job proving that. But retaliatory intent is not an all or nothing matter. Even under the higher but for causation standard, a plaintiff need not demonstrate that retaliation was the only cause of the employer's action. And given the nature of the response, a jury could find that the Wayfarer parties were motivated not just by fear of what would be disclosed, but by the protected actions Lively had taken in the past. So then we have the charges against Nathan, Abel, and Tag with aiding and abetting retaliation. They are entitled to summary judgment on a different basis, because the argument that they didn't abet, that they didn't aid and abet it is rejected. What it's saying is that they acted on instruction of their employers. That's what that is all about. Nathan and Abel were hired by Wayfarer, and it ends with Us Movie, to perform services on behalf and as their agents. Yeah? Tag is so implicated in this shit. The court withholds judgment with respect to whether Tag might be liable for aiding and abetting FEHA retaliation, because Nathan and Abel cannot be held personally liable for aiding and abetting retaliation. Judgment must be granted in their favor. The motion for summary judgment with respect to Tag is denied without prejudice. Failure to prevent sexual harassment. The court has granted summary judgment on Lively's FEHA harassment claim. Judgment must therefore also be granted on her failure to prevent harassment claim. False light, invasion of privacy was not recognized in New York law. So that was that one. None of these were saying that she didn't have a claim. Defamation, well, that's concerning Friedman. Unfortunately, Friedman seems to be within his rights to have done what he did. Apparently, it's totally legal to go and defame someone that you're involved in a legal case with on media channels. That's what this all says. The Wayfarer parties are entitled to summary judgment on the defamation claim. Conspiracy is also dismissed because regardless of whether New York or California's law of conspiracy governs, Lively cannot accomplish by way of civil conspiracy what she is unable to under FEHA itself. Because it permits aiding and abetting claims under certain circumstances, but it also places specific limitations on that form of liability. Lively cites no authority, and the court has found none, permitting a party to evade the carefully drawn limitations on aiding and abetting liability under FEHA by the artifice of pleading the claim in conspiracy. So that one was found in Wayfarer's favour. Conclusion. We're at the last page. The motion for judgment on the pleadings and summary judgment are granted in part and denied in part. Judgment is granted in the Wayfarer party's favour with respect to all counts in the second amended complaint, except for Lively's fourth cause of action for retaliation and violation of FEHA against It Ends With Us movie and Wayfarer, and 2, Lively's seventh cause of action against Tag, you know, for aiding and abetting retaliation and violation of FEHA, and 3, Lively's ninth cause of action for breach of the CRA against It Ends With Us movie. By order, Lewis J. Lehman. So that's it. I've got to the end of the document. Is anyone still with me? It's been a very long one, but I do appreciate everyone that contributed in the chat and everyone watching. Please don't forget to give the video a like if you want to see me making more content about this. I mean, I'll do it anyway, but it just helps me feel a little bit more appreciated. Guys, thank you so much. Sorry it's been so long, but as usual, I did as thorough a job as I could. I will see you all very, very soon. Have a blessed Easter. Good night. Goodbye and good night.